Bless the great sacred life and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is August 9th. I'm Judge Kapler. We have reviews to do first. Those are for people who have a file that they're working on, court orders. This is a review of your progress. So if you're here for that, your name's going to be called by the bailiff to come up with the group when your name's called, and I'm going to review your file with you. If you don't get called and think you should have been, if you're not set for today, you missed a hearing before, you need to go check in with the clerk, because otherwise we don't know you're here and you're not on the docket for that. Call the reviews, please.
Jonathan D. Bowman, Vilma E. Gurgley, Bruce Hall, Charles R. Hall Jr., Olivia Huff, Cody A. Keller.
Jonathan Bowman, TRC 22-1598, 22-194, 16-947. Jonathan Bowman is here. You did make a payment today.
Your Honor, if I may, Mr. Bowman was ordered on July 5th to be here on July 6th for community service, and he was not here.
What say you about that, Mr. Bowman?
I had something come up. My papa went to the hospital. Had to go with him.
Okay, I'm going to commend you in the hands of the sheriff at this time. You're going into custody. Vilma Gurgley, 23-1297, Vilma Gurgley. It's been called, has not appeared, has not finished what she was ordered to do, so there'll be a warrant issued for failure to appear. Bruce Hall.
Right here, Your Honor.
24-374. Theft. You're supposed to bring me some medical records.
Yes.
You got those?
I got this is where I had surgery. The other paper somehow got me lost, but it just shows where I had surgery like 2 weeks ago, Your Honor.
Yeah, 7/29/24. Okay, I'll give you some more time then to get this completed. How are you doing now?
Much better than what I was.
Okay. Well, you've got 5 days of community service and fines to pay. Can you pay anything on your fine?
I paid $100 a day, Your Honor.
Okay, I overlooked that. That's correct. I see that now. And are you still living out of the area, or where do you live now?
219 Forest, Seaman, Ohio.
Okay, that's the same address we had before, right?
Yes, Your Honor.
What county is that in?
Adams.
Okay. I'll give you a couple months then to heal up and get some of this stuff done. Let's set you for October the 11th. I'll write that down there in the basket. There's a form. Put your next hearing date on. October the 11th will be your next review hearing. If you get everything done before then, you don't have to come back.
October 11th at 9 o'clock, Your Honor.
Yes, sir. Charles Hall Jr.
Yes, sir.
24-118, 23-596, and he's with TTC.
That's right.
How's that going?
I mean, it started off a little rocky. I don't think he was necessarily prepared for treatment, but he's since being with us and going through detox, he's, I think, accepted the fact that he's going to have to see this through, and he's been doing better.
Do we need to do a screen today? Because his last screen that was done here was not very good.
I don't think so, but if
I'll go with your recommendation. So So he's doing outpatient right now, or?
No,
inpatient? He's inpatient?
Yes, he's inpatient.
Okay.
I'm impatient.
So you're doing screens there then?
Yes,
Okay.
3 a week.
All right. So then we won't do one, we'll forego doing one here and come back in a month.
Just
Sir.
happened, may I?
Yes, sir?
I'm in Bridges, it's a 30-day program. I was talking to my counselor. He said that transitional was for people that have nowhere to go, homeless people and out-of-town people, you know what I mean? I was gonna see if you can find a curiosity to let me go home after Bridges, after I complete my Bridges, do outpatient. My
I'm gonna
wife,
go with whatever your counselors recommend. If they think that that's the best course, then I'm on board with that. Here's what I wanna see happen.
yes, sir,
I wanna see you get clean.
yes, sir.
I mean, July, wasn't that long ago, July 26th, you were in here, I gave you a screen, you tested positive for amphetamine, benzodiazepine, methamphetamine, buprenorphine, and THC.
Yeah, my dad passed away. I
That's a
did
bunch.
too.
That's a
Yeah,
bunch of stuff.
Yeah.
So, you're not gonna function well out in the real world when you're doing, you got this stuff in your system.
No,
So we
I
gotta get
agree.
that cleaned up, man.
yes, sir.
So what, I'm not the professional. I've been around this a lot, so I've got some knowledge, but I'm gonna leave it to the professionals to devise the best way for you to get clean. And if they're on board with you going back and doing outpatient, I'm on board with it.
Yes, sir. I have to get that in writing. They take to my counselor, he said. That's what he told me. Because they can document it, you know what I mean? If they're on board with it.
I'll
And,
talk to him, Your Honor.
I think this guy right here can relay the message.
all right, that's fine.
It would be a first that I've had to write anything in writing, Your Honor.
That's what he told me.
Well, you tell the judge Trump that. The judge said, no, I don't have to put it in writing. I can issue an order from the bench, and that's what I just did.
All right.
Okay, September the 13th is going to be your next hearing at 9 o'clock. Okay. Sounds like you're on the right track. Keep it up.
Yes, sir, thank you.
Thank you, Your Honor.
Thank you, brother.
Olivia Hunt, 2573. 2573.
Your Honor, if I may?
Yes, go ahead.
As I was reviewing her case, she had two. She's actually completed one, and now she's working on the other one. So she has made progress on one case, and now she's...
My paycheck doesn't hit till like 4 or 5, so I can come in Monday and pay the rest of my fine off, if that's okay with you.
Well, I see this is an older case, but initially you were ordered to go have an assessment. And I don't know if that all got done on the other case, but let's just have you do a screening today, just to see where we are. If it's clean, then I won't require any additional showing of treatment. If not, then obviously we gotta go back to square one. Go do a urine screening. Cody Kelly. Cody Kelly is 18,292, 14,498, 16,661. Cody Kelly called, has not appeared, has stuff left to do, so there'll be a warrant issued for not appearing.
Kimberly A. Krantz, Tori L. Lindsay, James McClellan, Kelly R. Mintz, Ray W. Meredith, John Whipple.
Cameron Krantz.
Yes, sir.
Cameron Krantz is here, 23,695. You paid your fine.
Yep.
And you've done about a fourth of your community service. You still have some left to do.
Yeah, I'm coming tomorrow and Monday to finish the rest of it out.
Okay, what about Valley Health? You were at Valley Health?
Yeah, I brought you the paperwork.
You finished that?
Yeah, I finished all that stuff.
Are you paying anything on, well, your fine is paid, so you
Yeah.
gotta get your community service done.
Gotcha.
When can you get that done?
Tomorrow and Monday.
Okay. Well, you still have 30 hours, so it's gonna take more than that, so he's done 10 according to what I'm showing. Unless there's
He
more.
should have 10 left.
Okay, there's 10 left?
Yeah.
Okay. All right, then you can get that done in
Yes,
that
sir.
timeframe. So what I'm gonna do, I'll set you for September the 16th. But if you should have everything done by then, if you do, you don't have to come back.
Yes,
Just
sir.
get your community service finished. You don't have to appear on that day if you haven't finished.
Thank you.
Thank you. Tori Lindsay, 23,642. She has been in Mojave. Was supposed to go there for an assessment, supposed to bring that with her today. Tori Lindsay.
Your Honor, I believe she's in Boyd County Jail.
Okay. I'll issue a warrant for her for failure to appear. James McClellan.
Yes, sir.
Case number 21682, 181168, 163521, and you're Shawnee, right?
Yes.
You got a report?
Me up there, Your Honor?
Yes, sir. Thank you. Congratulations, looks like you're getting a job, right?
Yeah. Appreciate it.
Good drug screens. Excellent report. So good, I guess you guys are hiring him, right?
Right.
Okay. It doesn't get much better recommendation than that they would hire you. So how do you feel about things?
Great, awesome. I'm excited about it, for real.
All right, congratulations. You still have some community service to do. You can do it in Portsmouth at the.
All right, I was gonna ask if I could do it down there.
You can do it at the municipal court there, just have them send your hours up here. We'll
I
give you
think they actually said something about, can we do it, at treatment?
If
If
I'll
they
let
allow
you do it
it?
under their direction. If they say it's okay.
All right,
then
cool.
I'm okay with it, as long as they approve it.
Okay.
And you can also work off your fine if you can't afford to pay it. We'll give you $50 a day credit for
Sounds
anything
good.
extra you do.
All right, cool.
Okay, so, I call this a success story,
Yeah, for sure it is, man.
but it's not finished.
It's not finished.
So far, it's successful, but you gotta keep, it's
It's
like
gonna
every
be
day,
successful,
you know,
It's been a work in progress, for sure.
Absolutely. You understand that it's not something you say, well, I'm across the finish line, I can just go back to whatever I was doing before, hanging out with the same people, doing.
Yeah. I got 28 years in active addiction, man. It's been a long time coming, for real.
So, Rome wasn't built in a day, the old saying is, you gotta keep working at it every day, but
For sure.
congratulations, you're doing.
Thanks, man.
Good. So, I'll give you more time since you've done so well before you have to come back.
All right.
Let's make it October 4th, almost 2 months.
Appreciate it.
Glad you're doing so well.
All right,
October
man.
4th, 9 o'clock.
9 o'clock. Thanks, Your Honor.
You're welcome.
Thank you.
Kelly Mintz. 2366 and 18326. Kelly Mintz. It's not appeared, has done some things on the case, but hasn't finished. So it'll be a warrant for not appearing. Ray Meredith, 2038. Ray Meredith has not paid all his fines or finished community service, so it will be a bench warrant since he didn't appear today.
Yeah, he was not here anymore also.
Okay, thank you. John Whipple, 18388. John's OVP.
Probably wants to keep the certificate. John completed our inpatient program and he is compliant with outpatient at this time.
Okay,
He's
very good.
going
These mine to keep, or you want a copy? Get a copy.
get a copy of the certificate, yeah.
Okay, but the report's mine.
Yes.
Congratulations, Mr. Whipple, good job. I'm showing you have just 1 day of community service and some fines.
Yes, sir.
Okay, how you feeling about things?
Pretty good, really good,
What's the
actually.
next plan?
I got a job at St. Mary's the other day, so I start on the 26th.
Very good. Where are you gonna be living?
Over in Huntington,
Okay.
right by the old Belly Hills Middle School.
All right, so you're gonna be doing your outpatient with OVP then?
Yes, sir.
And there's lots of places there for you to go in Huntington. You're going to the one on 20th Street, I assume?
Yes.
Okay. All right, good job. We'll set you for October 4th also. October 4th at 9 a.m.
All right, thank you.
Thank you, Your Honor.
State of Ohio recalls Olivia Huff, case number CRB 2573.
Okay, it's an acceptable screen. I'll accept that. So you just have to pay your fines.
I've got some additionals.
Go ahead.
She's on community control sanction with Carl Bowen's office too, Your Honor. She has an ankle monitor on.
Okay.
She's in treatment through their department. They've got an initial report that she just started, but they're going to be, that's a requirement that she goes to treatment.
I know Mondays, Wednesdays, and Fridays, like, as soon as I leave here, I gotta go.
Where are you going?
It's the One Stop, it's called a WIP program.
Through CAF?
Yeah,
Okay.
it's basically more for my mental health than it is for, substance abuse.
But she has a conviction through common police court that she's going to be on community control sanctions with them for a little bit.
All right, well, I'll give you more. Since they're monitoring you, I don't have to monitor you as close. So I'm going to set you for October 25th as your next hearing here. So almost 3 months.
You said 25th or 5th?
25th. October 25th,
Okay, thank you.
9 a.m. Get your stuff finished here and you can quit coming to these.
Thank you.
You're welcome. Dan finishes the reviews. We're going to do the arraignment hearings next. Arraignment is what first hearing is called on a new case, or if you messed up an old case, you got a warrant, you'll get called with the arraignments. When your name's called, come up to the table to your right. Come on in, have a seat, Mr. Vice President. When your name's called, come up to the table to your right, stand there. I'm going to go over the charges with you. First thing, you need to understand your rights. You don't have to say anything. You have a right to remain silent. If you choose to make statements, it's all on the record. What you say can be used against you if you admit something about your case. You have a right to have an attorney if you're facing possible jail sentence, which most of the cases here are possible jail sentence cases. You have a right to have bail to make the state prove any charge against you beyond a reasonable doubt. Those are your rights. If you enter a guilty or no contest plea, you're waiving your rights. You shouldn't do that if you don't understand what's happening. If you want to talk to a lawyer, if you want a trial on your case, any of those things, or if you don't know what to do, enter a not guilty plea. That's always the safest plea to enter. You can change your plea to guilty later if you consider it, talk to a lawyer, decide you want to change your plea. But if you don't know what to do, enter a not guilty plea. Call the first case.
State of Ohio versus Robert Collins, case number CRB 24-409.
Robert Collins. Robert Collins, come into court.
It's not checked in, Your Honor.
Okay, there had been a warrant issued before. Okay, he came in, I guess he decided he didn't want any part of this. So there'll be a warrant, I hope it wasn't recalled, so there should be another warrant issued for failure to appear.
State of Ohio versus Lexus A. Anderson, case number TRC 241605 A and B. Mr. McCown's case.
Maybe we need to start putting those people in custody when they show up, when they got a warrant.
Mr. McCown.
Need Mr. McCown in the courtroom, please. Mr. McCown.
Good morning, Your Honor. I apologize.
It's my understanding you're going to be representing Ms. Anderson.
That is correct, Your Honor. Enter a not guilty plea.
Waive reading.
Yes, Your Honor.
You have a preference for a pretrial date?
Would the 23rd be okay? That would be 2 weeks.
Yes. Okay, pretrial in this case will be set for August 23rd at 10 a.m. It does look like she's posted a bond, so she can sign a signature bond, $1,500 signature bond. Not guilty plea is entered.
Thank you, Your Honor.
You're welcome. 10 o'clock, August 23rd, so it's here.
State of Ohio versus Charles N. Frazier, case number TRC 241625 A and B.
Charles Frazier. Sir, are you Charles Frazier?
Yes, I am.
Mr. Frazier, it's alleged that on August the 2nd at 5:37 p.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol. And it's alleged you took a breath test and tested 083 on the breath test.
83.
083.
No, he said point
Sir,
3.
just listen to me and then I'll ask you questions and we'll go through them.
All right.
Operating a vehicle intoxicated under Ohio law is a first-degree misdemeanor. The maximum penalty is 6 months in jail, $1,000 fine, and a 3-year license suspension. There is a minimum penalty. The minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You're also charged with failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is a $150 fine. Do you have the money to hire a lawyer?
No.
Do you have a job?
No.
Do you have any income?
I have disability.
Social Security disability?
Yeah.
Okay, you're eligible for a court-appointed lawyer because of your test score is low. I'm going to appoint a lawyer for you. I'll appoint Tyler Smith. Let's have Tyler Smith come in the courtroom, please.
Not in there, Your Honor.
Here he comes.
Yep.
All right, Mr. Smith, this is Charles Frazier. He's got a first offense ODI with a test score of 083.
Okay.
So I'm going to appoint you to represent him.
Okay.
He can sign a $1,500 signature bond. What's your availability, and let's see, what's the court's? Probably the 23rd of August or after is good.
The 23rd is fine, Your Honor.
August 23rd?
Yes.
August 23rd will be the next hearing. There'll be a pretrial at 10 o'clock. Not guilty plea is entered for Mr. Frazier.
State of Ohio versus Joseph Thompson, case number TRD 241623.
I think it would be helpful. Sir, are you Joseph Thompson?
Yes, sir.
Case number 241623. Mr. Thompson, it's alleged on August the 3rd at 11:31 a.m. in Perry Township, you were driving a vehicle without a driver's license. filed, this appears to be an unclassified misdemeanor. So what I'm going to do, you're going to catch a break today. I'm going to dismiss your case because the trooper messed up, and he filed, this is a non-jailable offense. He filed it in criminal court. It should have been filed in traffic court. Doesn't mean your license is reinstated. So if you go out here and get stopped 5 minutes from now, you can get charged again. If they file it in the right court, you'll have to answer for it. If they filed it in the wrong court, it should have been charged in traffic court rather than criminal court. So I'm dismissing your case.
Thank you, sir.
You're welcome.
State of Ohio versus Mark A. Rucker, case number TRD 2415A.
You're Mark Rucker.
Yes, sir.
You're going to get the same treatment, it looks like. Well, I'll ask the state, is there any reason that he's charged with unclassified misdemeanor driving under suspension? It appears from the face of it. Is there any reason that should have been filed here rather than traffic court?
Not that I know of, Your Honor.
Okay. Same thing that happened to the last gentleman. I'm dismissing it. That's the only way they're going to learn. If I dismiss their cases for filing in the wrong court, then maybe they'll start filing in the right court. Because we have a traffic court for non-jailable cases. Your charge is non-jailable. They filed it in the jailable court. So your case is getting dismissed. It doesn't mean that you now have a driver's license. It's probably still suspended, and I would encourage you to get with the BMV and figure out what you got to do to get reinstated.
My license is reinstated, Your Honor.
Okay. Well, regardless, this is getting dismissed. So whether it is or isn't, your case is dismissed because you should have been cited in the traffic court rather than the criminal court.
Thank you, Your
Case
Honor.
is dismissed. Whoever's got the dog, mute your microphone. Thank you.
State of Ohio versus Heidi R. Meadows, case number CRB 23341.
Ma'am, are you Heidi Meadows?
Yes,
Ms. Meadows, it's alleged you missed a review hearing on August 2nd, so a week ago.
Yes.
And it was on a theft offense. Your community service is done. You still have a little bit to pay on your fine.
I'm gonna work it off 4 days after school starts. It starts the 15th. The next week after that, I'm gonna do the 4 days and it's gonna be done.
Okay, I'll withdraw the warrant since you came in on your own. I don't think a warrant actually even got entered yet.
I called yesterday, he said no.
Okay. I'll set
I
your
was
next
thinking I was
hearing-
supposed to be here today anyway, I'm sorry.
I'll set your next hearing in September. If you get it done by
Yeah.
then, you don't have to come back.
September what?
Well, that's what I'm looking for.
Okay.
September 20th.
It's gonna be done.
Get it done before then, you don't have to come back. It'll be set for September 20th, 9 o'clock.
Thank you.
You're welcome.
State of Ohio versus James Conley, case number TRD 222537 and TRC 222720 A, B, and C.
And you're James Conley?
Yes, sir.
Mr. Conley, you had a review hearing on August 5th, it looks like, which would have been Monday. And you failed to appear?
Yes, sir. I was at the hospital. I had an accident and messed my hand up. I'm gonna have surgery done on it as soon as we get find someone, the orthopedic surgeon, to do it.
Okay. Do you have anything medical with you?
Yeah, I've got a doctor's note for that morning.
Mine, Keith?
Yes, sir.
Okay. All right, it does say that when you represented the court, so no warrant was issued, hadn't issued yet anyway. I'll give you some time to get it straightened out and get your stuff finished. So I'm going to set it for September 27th as your next hearing. Get it done by then, you don't have to show up. You got stuff still left to do, you got to be here at 9 a.m. September 27th.
at 9, right?
Yes, sir.
Okay, thank you.
You're welcome.
State of Ohio versus Paul Snavely, case number CRB 24318.
Okay, this is Mr. Smith's case.
It is, Judge. Yes.
This was set for Monday, looks like for a pretrial, and he wasn't here then. Is that right, or was it COVID?
Yeah, no, I wrote down the wrong date. I'm in the Regal recovery period.
Okay.
And I wrote down the wrong date.
Judge, he's at Regal Recovery. He says he wrote down the wrong date and he's coming to make it right today. I would ask him to be put back on the,
So you got a report from them as to, was there anybody here with him?
Yeah, I have somebody here with
Can
me.
you come up, ma'am?
She doesn't have a report though.
can she maybe give an oral report?
You give an oral report.
Yeah.
Yeah.
Okay.
Would you identify yourself, please?
My name is Kelly Hardesty.
And you work for Regal?
Yes.
Can you give me a verbal report as to how Mr. Snavely is doing?
He's doing very good, very compliant with our program, following the rules and everything he needs to do.
Okay, he's inpatient?
Mhm.
All right, how do you want to proceed, Mr. Snavely?
Judge, if we could, he's inpatient, probably come back. I don't know how soon you want to come back.
I was going to dismiss it if I complete the program, so.
Yeah, but you're still in. Yeah, okay, yeah. We're not there yet. But yes, if we come back maybe 30 days, Judge.
Okay, what's your schedule in September?
Judge, I could do the 6th, the 9th, the 13th.
Let's do the 13th.
I can do that.
September 13th will be the next hearing. It'll be a pretrial, 10 o'clock.
If you could bring him a written report next time for the file.
Okay.
Yeah, try to get me a written report next time.
Okay, sorry, thank you.
Thank you.
State of Ohio versus Elizabeth Hoffman Howard, case number TRC 22-164A and B, TRC 19-3458A and B.
All right, she had a review hearing a week ago, on the 2nd. She's here today. Do you have an explanation for not being here on the 2nd?
I do. It's not a very good one, but I honestly write down the wrong date. I carry this calendar everywhere. I have proof that I must have just I don't know. So when I called a couple days ago, they said, no, you missed it.
Okay.
I said, I haven't written down. Yes, I have a progress report from PATH.
It's on her phone, Your Honor.
I can't remember your email.
They don't email me or fax me.
She said she faxed it, but you guys never get it.
We never receive them.
Well, this is actually, I have this one.
You have?
It's June 24th, so that's an old.
No, that's not it. That's not it.
I've got that one that you just showed me in your file.
No, that's not it. I'm sorry, I pulled the wrong one up. This is August 8th. There it is, I'm sorry.
Okay, try it again.
Yeah.
Your next appointment is August 14th. Can you forward that?
I'll have her, yes.
All right, so I'll set that. No warrant to be issued since you came in. Set your next review. September 16th. September 16th will be your next hearing. 9 o'clock.
All right, September 16th. Thank you, Your Honor.
You're welcome. You're doing good.
Thank you.
Yeah.
I got my driver's license as well.
Congratulations.
I'm happy for that. Thank you.
State of Ohio versus Matthew S. Smith, case number CRB 21-692, CRB 15-457, CRB 14-553, CRB 14-665.
Okay, your hearing was set for Monday, it looks like.
Yes, sir.
Do you have an explanation for not being here then?
I have some stomach issues going on, Your Honor. I have some surgeries coming up, and I just had, I was really sick. I just couldn't make it in. I called. It was really not a good one, but it's the truth.
Okay, and can you pay anything on your fines today?
Yes, I'm gonna pay $25 on my fine today.
25?
Yes, sir.
Okay, September 6th will be your next hearing.
All right. Thank you, Your Honor.
You're welcome.
State of Ohio versus China R. Scott, case number CRA 24265.
This was set for a preliminary hearing on August 2nd, and my record shows that Scott was not here today.
She got confused on the date, Your Honor. I have a report for you from Chesapeake Healthcare. Shows her clean and compliant.
Okay,
That one is yours to keep.
thank you.
You're welcome.
Okay, it's a good report. Screens are good. It sounds like she's going to all her appointments, doing what she's supposed to. So this was a case I believe the state was going to keep here as long as she was compliant with treatment.
Yes, Your Honor.
And you're still willing to do that?
We are, Your Honor.
Okay. Okay, let's make sure we get the right dates down and get here when you're supposed to be here. I'll set it for September the 13th.
All right, I'll do better next
Is
time.
that available then, Mr. Murphy?
I believe so, Judge.
Your Honor, what's the case number on that?
The
It is
13th?
24-265.
The 13th?
Yes.
I'm here.
Okay. September 13th is our next hearing.
Is that a Friday?
That's a Friday.
Friday, okay, good.
You're good.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Dolores E. Hill, case number CRB 23568, CRB 23536. Dolores Hill.
Dolores Hill, set.
She's here, Your Honor. I just had her check in or let her.
Dolores Hill, come into court.
Your Honor, Ms. Hill was scheduled last Friday. Didn't appear, she had card, or didn't have a ride. She is here today, and I'd asked to give her time to get in before a bench warrant was issued, so she is here today. My understanding is that you have moved or getting ready to move?
Yeah, I haven't moved. I'm living south side, West Virginia, in Mason County.
It's near Point Pleasant.
Yeah.
And I believe she's going to be going to Prestera
Yeah, and Point Pleasant.
there. You've been to Prestera before, right?
Yes.
Yeah.
What's the state's position?
We're not,
Probably don't have the file.
well, I just now got it.
Okay.
Need to look at it.
This is one where we had to get her back on medication, which has helped.
She's still going to Prestera?
Yeah, I'm scheduled today at 3:30.
I mean, we're not opposed to a continuance, Your Honor. We need a time waiver.
We'll waive time and we'll get a report from Prestera at the next hearing.
Okay. So looking, do you have any restrictions in September as when you can't be here?
No, Your Honor.
Okay.
That'll give me plenty of time to get record to.
I didn't hear what she said.
So that'll give me plenty of time to get the record to from
September
like
13th?
appointments.
That's fine, Your Honor.
September 13 will be, the next hearing will be pretrial on both cases.
Thank you, Your Honor.
You are.
Thank you.
Okay, we have some more arraignments coming, but the paperwork's not finished, so when we get those, we'll call your case up. So now, we're going to go to pretrial.
State of Ohio versus James C. Jones, case number TRC 23536. Mr. McCown.
McCown's case, James Jones.
Your Honor, he's here.
We'll recall.
I apologize.
State of Ohio versus Mark L. Blackburn, case number CRB 24364. Mark Blackburn.
Mr. Smith's case, Mark Blackburn.
Judge, I did not see him earlier today. I don't know. He's charged with an M4. The state was considering possibly a domestic charge also, but I don't know that they've spoken with the alleged victim yet. So I don't know where we stand other than I don't know why he's not here.
Mr. Hill.
Well, actually, Your Honor, in reviewing the facts of the case, I believe that the law enforcement officer meant also for us to consider a domestic violence charge, and the facts as it's presented look like that's what ought to happen. We don't have an original affidavit with which to file a charge at this time. As far as him not appearing, we just asked for a bench warrant.
I have 7 days, Judge. I'll see why he's not here if I can answer.
Yes. He's got 7 days before the warrant will issue.
China.
State of Ohio versus Shelley Clay, case number CRB 24162. Shelley Clay.
I'm 0 for 2 today so far. She was set Monday to be a 90-day dismissal continuance. We've tried her. My secretary calls now. It's not even going to voicemail. The phone just rings. I hate for a warrant issued, but I don't know what else to do at this point.
All right, she's got 7 days to get in here before a warrant will issue.
We'll keep trying.
State of Ohio versus Brittany M. Jones, case number CRB 24452. A and B.
And Jones is also Mr. Smith's case, pretrial.
Okay. Go ahead, please. Does she want to get it done today?
We could if you'll make an offer.
We would nolly the obstructing and have her plead to the resisting and get 30 days suspended.
30 days suspended license?
Suspended jail time, so you wouldn't go to jail. You live in Florida?
Yes, sir.
She's just stayed up here the next couple weeks to get this done. She's heading back to Florida.
Go back to Florida. We wouldn't care if it was non-reporting probation, Your Honor.
Judge, based upon that recommendation, she understands I've not filed discovery yet, but you want to go ahead and do that.
So I get probation?
Non-reporting.
No.
Yeah, you don't have to come back up here to report. Probably do it by telephone and just stay hooked.
And then do I have to make payments on that?
Court cost. You didn't recommend a fine, did you?
We didn't recommend a fine. I don't know what the judge might
$150
do.
court cost. Make payments on that.
Yeah, I'll do it.
Okay, Judge. Well, we'll change our plea then to guilty to the resisting, and I understand the instruction will be dismissed by the state.
That's correct.
Okay, do you agree with what your attorneys represent to the court, Ms. Jones?
Yes, sir.
You have a right to make a statement. Do you have any statement you wish to make before I sentence you?
I just want to say one thing. I've been being kind of harassed by the police these last couple weeks. I have videos of everything. And that's it.
Well, do you understand what your attorney is saying to the court is you're entering a guilty plea to resisting arrest? That's a complete admission that the charge against you is true. Can you understand that?
Can I do no contest?
No.
No, you're not.
Sorry,
You want, you have no contest.
we don't oppose a no contest.
Judge,
as long
I
as
would
there's a-
withdraw their guilty plea since it's not been acted upon yet, and in its place enter a no contest plea with stipulation of facts sufficient for finding of guilt if she would proceed to trial.
So what that means is, no contest means you're not putting up a defense to the charge, you're not admitting that it's true, because you're not defending against it either, and you're saying to the court, Mr. Smith is saying to the court, we stipulate that if we have a trial, there's enough facts for the court to find me guilty. That's what you're saying, but I'm not admitting I'm guilty.
Gotcha.
Is that what you want to do?
No
You
contest.
guys say yes?
Yes.
It's recorded.
Yeah.
All right, I'll accept your no contest plea, make a finding of guilty on the stipulation. The A case, the obstructing justice is dismissed. Okay, court, the state's recommending no fine, but payment of court costs, I'll assess the court costs. 5 days in jail suspended. Level 5 probation. She will have a review hearing on January 31st. So as long as you pay your court costs before then, you don't have to appear. If you haven't paid it, you gotta appear. If you don't appear, a warrant will issue for not appearing. So
Okay.
just pay your court costs and it'll be over.
Yes, sir.
Meet with the probation officer, Mr. Major, before you leave. Get your paperwork. Do you have any questions of me?
No, sir.
His office to the left.
To the left.
That's only if you don't pay costs.
State of Ohio recall to James C. Jones, case number TRC 43536.
And Mr. McCown is representing Mr. Jones. Case set for pre-trial for that.
That's correct, Your Honor. Your Honor, the court will recall that we set and had a suppression hearing in this matter. The court partially suppressed some of the evidence and denied it. As a result of that, it's my understanding that the state would move to amend the charge to physical control, and to that, along with the jointly recommended sentence, to that Mr. Jones would enter an alpha plea of guilty. She's, of course, maintaining his innocence and denying it, but acknowledging the likelihood of a conviction.
Is that correct, Mr. Jones?
Yes, sir.
Yeah, you have the right to make a statement to the court if you want before the sentence is pronounced. Do you have any statement you want to make?
Yes, sir, Your Honor. I'd like to thank the prosecutor for giving me the recommendation that he has.
Okay. The charge will be amended from OVI to being in physical control of a motor vehicle while under the influence. So that's 4511-194. I'll make a finding of guilty based on what's been placed. Should be. Okay. I'll impose a $200 fine for costs and a 10-day jail sentence suspended. $200 fine, court costs, 10-day jail sentence suspended, review hearing, make it non-reporting of probation. January 31st will be his first review hearing. If he pays it before then, he doesn't have to come back. I don't know if he has any other matters still before the court, but this doesn't interfere with any of those. If he does, I don't know if he has other reviews. So.
Okay, thank you.
January 31st, 9 o'clock for this one.
When you get the probation officer,
Do you need, does he need to see
check
this
with Mr.
information?
Major. Yeah, get his paperwork from him.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus Claudia Ann Cyrus, case number CRB 24447.
Your Honor, I've talked with Ms. Cyrus. There is we have a bill, a medical bill, and part of the recommendation will be to pay restitution. So at this point, we'd waive time if we can come back September 6th, she's got to make a couple of payments. She'll have 2 paychecks within that time and deal with it on September 6th. That's a possibility.
Okay, now there was other things the state was asking for previously, is that being addressed?
Well, that'll be addressed too. I think it was to register the dog, and there'll be insurance. But as far as the fence, she lives in an apartment complex, so she has no control of the fence, and the fence isn't part of it.
Well, and those are, I mean, that's a reality. It doesn't sound like it's possible for her to have a fence because of where she lives. However, she's going to have the responsibility of not letting the dog out in any way if it's not secured properly. And the insurance, of course, is for the purpose of making sure that if it did happen again, that the expenses that would be incurred would be covered by insurance.
And she could get renter's insurance, which I think could cover that.
And then there's also the dangerous dog, I don't know if it's a license or whatever, registration through the county that's required too.
And she's aware of that, Your Honor, and I believe in exchange for that, it would be admitted back to a minor misdemeanor on the 6th.
Okay, that's true.
Well, we want to make sure that the money.
Right, that's why we're
restitution
continuing.
is
How much is the restitution?
$547 and change.
$547.52.
Okay. Is there something being paid on that now, or?
She gets paid on the 15th and the 1st, so it would have to be, she can come in and pay part of it after the 15th, which will be next week, and then again after the 1st. That's why we asked to continue to the 6th to make sure everything's paid.
Okay, so is she changing her plea now, or we're just going to let it pen?
Just wait till the 6th and do
Okay.
everything then. We just want to let you know what the plan was. That's why we asked for the continuance. So I know right now it's in 4, and it would take it past the statutory limits, so we'd wait time until the 6th.
Your Honor, the parents of the child are here, the child that was bitten, and I think that they're not able to come to court again because of work, but I think that maybe they want to make their wishes and feelings known to the court.
Sure, do you have a statement you want to make?
We have not seen the dog off since we've been here. As long as the dog is secure, I love dogs. It was just such a traumatic experience for us and the kid. However you feel, I don't want the dog to be put down per se, but I just don't want it able to run around. And it seems like she's tried to keep it on a tether or something, and I know they escaped, but I understand.
Well, I don't think there was any intent.
No, sir.
It wasn't an intentional thing,
Absolutely.
but there is a leash law in Ohio. You have to keep your dog under control, either on a leash or a fence or something that keeps it up. So it's an unfortunate consequence. But you folks are in agreement with the restitution amount, $547.52?
Yes.
So it's not meant, and that's stipulated to.
We have the bill, Your Honor, that's what it is.
Okay. Because I have to do that at the time of sentencing. I can't do it at a later time according to our Supreme Court. So it's not necessary for them to be here to give testimony on that since it's been stipulated to.
Yes.
Anything else?
That's it, Your Honor.
Okay, I'll continue this case to September the 6th. I expect then there's going to be a plea with restitution order and other obligations that have been agreed to between the state and the defendant. at that time.
What's the date, Your Honor?
September 6th. They're welcome to be here. They're not required to be here.
And I just do that through the
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kayla Kinzer, case number CRB 24464. Kayla Kinzer.
This is Mr. Smith's case. Kayla Kinzer, she was at ODP.
That's my understanding too, Your Honor.
Mr. Ben is here.
I haven't seen her yet, but it doesn't mean she's not here, I just haven't seen her.
Kayla Kinzer.
Oh, Your Honor, I believe she's the one that ran from the methadone clinic.
Okay.
Yes.
That probably explains why I haven't seen her today.
And this was a misdemeanor, so there'll be a warrant from this court. Thank you for that report. So the bench warrant for failure to appear.
Thank you, Your Honor.
State of Ohio versus Christopher J. Blevins. Case number CRB 2286, TRC 21595 A and B, CRA 21162.
Community service.
CRB 19439 A and B.
For 3.5 hours? Yes. May I approach, Your Honor?
Yes. 3.5 hours community service. Okay.
And Your Honor, Chris is compliant with outpatient. The only issue we have, he misses a few of his appointments. I believe that's due to his work schedule though, and he does always make those up, but we would like to see him, if he's going to miss an appointment, just reschedule it instead of missing it.
Yeah, the polite thing to do, and when you know you're not going to be able to make it, call them and let them know. They can reschedule something else rather than that person sit there and have a blank space of time. State's position. Mr. Cooper, I've got facing hunger food bank. So I don't know if that's something you approved.
We got 25 to do, and minus those 3.5.
So he still has community service to do?
Yeah, a little over 20 hours, I believe. Did 25 last time, and then 3.5 hours off that.
Well,
We're done.
I guess there's a reason for him to come back just for that.
Yes, we got old cases. In this case, it's still not resolved. I don't know what the state would be looking for at this point.
Well, I think that, I mean, this is
It's an old case.
2.5 years.
Domestic.
Yeah, and we would be looking at a dismissal with the payment of court costs once it's determined that, I guess, his other business is done and he continues to do what he needs to do with his treatment.
Agreeable with that?
Yes, Your Honor.
All right. We had a time with Mr. Blevins, I know him pretty well. This is, I think, the best you've done.
It is.
So, congratulations on that. You're doing good. You got to keep working at it.
Yeah.
I think hopefully you realize that at this point.
He does.
So we'll have you come back in 6 weeks or so.
All right.
Keep working on your old cases too. You still have some obligations to take care of.
I brought some money for fines today.
How much are you paying?
I think I have $50 on me.
Okay. Does it matter if it's Monday or Friday for your hearings?
No, sir.
Okay. Make it, are you available the 27th, Mr. Stratton?
September? Yes. Yeah, that'll work.
September 27th will be the next hearing. September 27th.
All right, thanks.
Thank you, Your Honor.
See the clerk, make the payment.
State of Ohio versus Brian Crawford, case number CRB 24330.
Your Honor, we still need the video here. The prosecutor does have the video, so if we can set this maybe in a week or so, we'll have that video to review. Maybe a week and a half.
You're getting it today, or you already?
We've got a copy here.
They've got a copy now, so hopefully I'll get it today.
Okay.
Did she put those in a slot in there?
But I don't have that one, so.
Okay. Next Friday's pretty bad. The 2 weeks would be better. if that's
2 weeks is fine.
23rd?
Yes.
September 23rd will be the next hearing. 10 o'clock. Did you September 23rd, 10 o'clock. I'm sorry,
Oh,
August
August
23rd. I said September. August 23rd. August 23rd, 10 o'clock.
Your Honor, this next case is a little bit out of order. Mr. Williams, I asked that this one be called up on the guest and prior evidence.
Okay.
Case number, or State of Ohio versus Andy Chapman Jr., case number TRC 24780, CRB 24213, CRB 24289.
Set for sentencing Mr. Morford as the attorney. Got a report from RRS. Okay, it's not a good report. Set for sentencing today.
Non-compliant due to lack of attendance and notice. That's not good. You're getting married. You're getting married, big kid. You're going to have to get together. You're going to be going down another path. What's the victim? What's the victim? I can't hear you.
So there's already been guilty pleas entered on 2 OVIs and an endangered children charge. The report I have today from Mr. Chapman says he's non-compliant.
Yes, Your Honor, he hasn't been in services in over a month. He's due to be discharged.
So I think we should just go ahead with sentencing today. What's the state's position on sentencing?
Okay, well, we've got 2 OVIs, right? He pled to both of those.
Yes.
And
One April the 15th, one May the 13th, so about a month apart. One with a test score of 117 BAC, that was the first one, April 15th. The one May 13th was a 122 BAC. And it also had failure to have child restraint and a left of center, and that's what the child endangerment charge was on also. And that appears to be
Instead, he's liable to handle it. You did it.
and an assault charge.
Okay, I don't think I've got, what's the case number on that?
24-213.
Yes, I do have it.
I don't believe we, so that one is still pending.
Okay. And that's the same day as the first ODI, April 15th.
Yes, Your Honor.
Alexis Rice is the complaining party.
Yes, and she's here today. So our intention on that case was to seek a conviction. And You know, I believe under the circumstances that he's accumulated a whole lot of bad stuff here. And his unwillingness to try to correct some of this through treatment apparently hasn't really sunk in with him. And I think that under the circumstances that this is deserving of a fair amount of jail time.
Now, was there a plea to the assault or just the ODI?
2 ODIs and the endangering, I believe.
Okay, so the assault's still pending?
Yes, but what I was going to suggest, Your Honor, is that because what we're going to ask for is a sizable amount of jail time and actually commit him to that. And then if he wanted to crawl back before the court at some time in the future, we may listen to his plea to go to treatment after he's had some time to think about it. And I would suggest to him that if he doesn't want us to ask to pile more time on top of that, then he ought to deal with this assault charge right now too, and plead guilty to it. And then we're going to ask for 6 months in the county jail on all of it.
Mr. Morgan.
Judge, do you mind recalling this and let me speak with him?
Okay. Do you recall he's ordered not to depart from the courthouse? He has a bond up, so.
What?
Case will be recalled.
Thank you, Judge.
Thank you, Your Honor.
State of Ohio versus Toby T. Morrison, case number CRB 24-324, A and B.
Your Honor, I believe that the prosecutor wants this to be reset for another pretrial. They're still trying to get the estimate from the alleged victim in this case, so we'll ask that be set for another pretrial.
Yeah, for reference, I'm looking at the 23rd or after.
Ever how long the prosecutor think it'll take for them to get that?
The issue is, I believe, that the victim works out of town and hasn't been able to get back to us. But, so a couple weeks would be adequate.
23rd or 30th? 23rd is 2 weeks.
23rd?
Works for us, sure.
Yes.
Okay, August 23rd will be the next hearing. Looking for
Once
a
we get
report
that,
on
we'll go on. All right.
the victim on restitution.
You're good to go. All right, good.
Michael L. Tilley Jr., case number CRB 24-437, State of Ohio versus Michael L. Tilley Jr.
It's Mr. Stratton's case set for pretrial.
Your Honor, Mr. Tilley is willing to, the prosecutor recommended that he be assessed for treatment, follow those recommendations, and that could possibly, if he successfully completes that or the recommendations, that will resolve this case.
Does he have an ability to pay or a medical card?
Do you have a medical card?
Yes.
Ohio?
Medicaid, yes.
Okay. And you live where?
I live in Ironton.
In Ironton?
Yes.
Okay, so we need someone that can evaluate Mr. Tilley, preferably that has an office in Ironton. Any volunteers or takers on that?
Sorry?
Does he have one to get to South Point?
I'm sorry?
Does he have one to get to South Point?
Do you have a way to get to South Point?
Yeah.
Yes, yeah.
Yeah, yes, I do.
Okay, so Bethesda, for evaluation, let's come back maybe 3 weeks to see how things are going.
Yes, Your Honor.
August 30th?
Yep.
August 30th will be the next hearing, will be a pre-trial at 10 o'clock.
Okay, August 30th. All right, talk to this gentleman back here.
State of Ohio versus Daniel L. Turner, case number CRD 23-732, PRD 1562A and B, and CRA 24457.
Your Honor, I spoke with Mr. Turner this morning. He had some legal issues.
Not here, though.
No, on the phone.
Okay.
He had some legal issues in Kentucky. He's not able to get here today, but he said he'll be here on Monday.
He's supposed to be at Bethesda, has he been? No?
Yeah, kind of.
Yeah, he got assessed, but he's not, the last time he was here, I know he had been in jail and was unable to come for services, and he's still not attending groups.
All right, he's got 7 days to get in before a warrant issue.
Yes, Your Honor.
Yeah, these are all misdemeanors, so they'll be from this court.
Is this Daniel Turner?
Daniel Turner.
So I've got a
No, wait, he does have
possession.
He has, I'm sorry, I missed it. He's got a felon.
Yeah, there's a possession and a menacing.
It's a possession, recent possession charge, so that change is, I guess it's up to the state if you want to keep it here or you want to send it on down to Greenwood.
We're okay to have a warrant.
So the warrant will issue from this court. And he has this will make it even more interesting. I think he has a bond up. Let's see. He does have a bond up. Release the hounds?
Yes, Your Honor.
Okay. I'll notify Mr. Sowers, give him something fun to do this weekend. I guess it'd be good to advise Mr. Turner to hide out till I would come in Monday if I was him, if I didn't want to go to jail.
Yeah, I don't know if I'll advise him to hide out, Your Honor.
Well,
but I advised him that he's on the schedule today. I told him, you're on the schedule today, you have to be here today. And I'm like, if not today, then I also offered him to, by video, but I said at least Monday, you got to be the very next day, so.
okay, I've just notified Mr. Sowers. I'm going to tell him what did Mr. Turner tell you was the reason he couldn't be here? Said he had legal issues in Kentucky?
Your Honor, he was just apparently released from either Greenup or Boyd County Jail this morning. So.
But he's not in jail.
He is not in jail, no.
So I'll set a bond forfeiture. Let's make it August 30th for bond forfeiture. What I'm texting is to Mr. Sowers, the fact that he failed to appear when the bond forfeiture is. All right.
Table High recalls Andy Lee Chapman, case number CRB 24289, CRB 24213.
Mr. Morford's case set for sentencing.
Judge, I believe that he's going to have a change of plea with respect to the assault case.
Okay. Is that correct, Mr. Chapman?
Yes, sir.
And
Guilty.
this is the complaining party on that. That's case number 24, is it 24-213 or 289? 213. 213. Alexis Rice, that's you, ma'am?
Yes, sir.
And is Mr. Chapman somebody known to you before April 15th?
No, sir.
He's a stranger to you?
Yes, sir.
But he was bringing some people to your house or something, or?
No, me and my boyfriend was at his mother's house. And ever since February the 4th at 7:45 a.m., I don't know if they're dating or not. I was told they were, I'm not sure. But Haley Christian kept messaging me and calling me nonstop. Well, later down the road, he got into it somehow. And then as we was spending her birthday at her house, they kept coming back and forth, driving past us nonstop. And we told them to leave us alone, that we was trying to spend time with my boyfriend's mother. And then they came through again, so my boyfriend's mother threw out Stephen Elliott's and Heather Hall's stuff. And then they came over to get it. He kept getting into my boyfriend's face. They kept arguing, and then I stepped into between them. And then he pushed me and spit on my face, so I hit him.
Okay. What's the connection between your boyfriend's mother and him? I don't get that.
I'm not really sure. He was basically drug into it by Haley Christian, because he was the person driving.
What's the connection between Haley Christian and your boyfriend's mother?
The connection there is a long time ago in the past. She is Heather's Hall's boyfriend or sister, and Heather is dating Stephen, which is my boyfriend's brother.
Okay. Mr. Deal.
Well, wasn't sure about all those connections, but
Kind of tenuous.
our opinion is, though, that, I mean, obviously what he did was an assault, and all the other things that he has done they've just amounted, I think, to a pretty serious situation. Then you add to it that he doesn't seem willing to try to mitigate any of this through trying to show better behavior and show cooperation and treatment. So if you're asking for the court's or the prosecutor's recommendation, we believe that he ought to get 6 months in jail, all of it, as a total. And we would not be opposed if at some point he would come back to the court and say, my behavior is going to be better from now on and I'm willing to go to treatment now. But I think he should serve some time in jail for this, as too many things have happened.
Mr. Morford.
Your Honor, I've had a couple of rather heated conversations with him this morning, and I believe he's ready to take his punishment and put this behind him.
Okay. And Mr. Chapman, what say you? So you have a right to make a statement to the court if you want to. Want to say anything, explain your conduct, or, what I would like to know.
I mean, we never
Wait
drove.
a minute, I'm not finished. What I would like to know is, you had the opportunity, gave you the opportunity to go to treatment and to kind of, you know what mitigate means? Somebody used that language. Mitigate means make things better. You could have made things better for yourself by showing to the court that, hey, I know maybe I've got a problem here, I'm going to address it so that this kind of stuff doesn't happen anymore in the future. But what I'm seeing from RRS is you blew it off. I mean, are you not afraid of going to jail? You got all these cases pending and you're blowing off going to treatment. Not a good idea. So any explanation of that?
No, sir. No, Your Honor.
Okay. Well, okay. Let's start with, I'm assuming from what you said, you don't have any restitution, you didn't have to go to the hospital or anything like that?
No.
Okay.
We are going to ask for no contact order, though.
Okay. On 24-213, we'll start with it. I'll impose a $150 fine, order court costs be paid, 180 days in jail, 2 years of level 4 probation, no contact order with Alexis Rice. So he's ordered, you're ordered to stay away from her, not go around her, contact her, post things about her. And we've also got, we'll wait till she finishes that one. PRC 24780, that's the ODI charge. I'm just looking over the report. Okay, on the ODI, and there was a guilty plea on that. $500 fine. Order to pay the court costs. License suspension for 6 months from the date of the incident. 180 days in jail. And it'll be concurrent with the assault charge. 30 hours community service, 2 years level 4 probation. Yeah, at this point he has to go to the driver intervention program. I might change that later if he goes to inpatient treatment. But for now, he'll be ordered to do that because it's a requirement under state law. So I think that will finish those 2 cases.
There's a second ODI.
I'm sorry, there was a second, yeah. That finishes this. We need review hearings. Want me to give you? Let's change it. Let's make it, October the 11th. That takes us to 24 TRC 970. That's the May 13th ODI. There's a guilty finding or guilty plea on that. Okay.
number on this?
24970 TRC. Okay, I'll make a $600 fine on that, since it's higher test score and it's the second within a month. Court costs, 6-month license suspension. Yeah, it'll be a 6-month. It's still a first, he has 2 first offenses. So I'll make it a 6-month license suspension starting May 13th. $180 days in jail, concurrent with the other 2 cases. 2 years of level 4 probation. And let's make it 60 hours of community service on this one, since it is the second within 2 months. He's got a total of 90 hours of community service. He's going to report to jail today.
No, I don't know. He said,
Yeah, let's make it October 11th.
would that be at 9 or 10, Judge?
9. He's got a, I don't know if it's the B case, but there's a child safety restraint. Okay, left of center is the B case, so $10 fine on that.
So what's this going to be?
Child safety restraint, that's a mandatory $100 fine.
You have to say. And on the, and he had his 3-year-old son in the car with him. I'm reading the report. So I'll impose a $250 fine on that. No court costs on it because there have been a cost assessed on the OBI, which was at the same time. So 180 days in jail, concurrent with the other cases. Review hearing is October the 11th on everything. He's commanded in the hands of the sheriff at this time. Thank you, Judge.
Thank you.
You too.
Hey, Butch. Hey, Butch. Is Michael Tilly, is that yours? Hey, Sean. Yeah. Michael Tilly.
Okay, on Daniel Turner, I think that was your case, Mr. Stratton?
It is.
I had texted Mr. Sowers, and he worked a miracle. Apparently called him, and Mr. Turner told him he didn't have a ride to get to court, and he said he would come and give him a ride, but it was going to be to jail rather than the court. He says miraculously, he just found a ride, he's coming from Ironton.
I'll be silent on
It's
that.
all about motivation. When you get the right motivation, you get stuff done.
You don't want to stop. Yeah, you don't want to avoid it.
State of Ohio versus Christopher McBride. Case number CRB 24494 and CRB 24379.
This is set for arraignment today, and sir, you're Christopher McBride?
Yes, sir, that's me.
There's two charges, 24494, 24379. 379 should be being handed a copy of the charge right now.
Yes, sir.
Is a domestic violence charge. It alleges that at Fayette Township on June the 10th of this year, you knowingly caused or tried to cause physical harm to Tanya Prosser, and that Tanya is either a member of your family or lives in your household.
Yeah.
That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Then 24494 is an assault charge. That alleges that at Fayette Township on August the 6th, you knowingly caused or tried to cause physical harm to Paul Hill. That's a first-degree misdemeanor assault, maximum penalty 6 months in jail, $1,000 fine. You understand these two charges, sir?
Yes, sir.
You understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
Not guilty.
Do you want to be
I want an
considered
attorney,
for a
I'm
lawyer?
I'm disabled, I'm on Social Security.
That's your only income?
Yes, sir, I have a very bad heart condition, and I would like to ask for a protective order against Mr. Griffin. He's not a tenant of the residence of the apartment complex, he's a guest, and he assaulted me to begin with.
I'll appoint Mr. Stratton.
Yes, sir. And I'd like to file charges against him for domestic battery on a disabled person that's terminally ill.
Stratton will be appointed to represent Mr. McBride on both cases.
I'd like a protection order as well because he's very young and I'm not capable of defending myself for very long. And like I said, I'm scared.
Well, he's not here, so I can't order him to do anything. He's not before the court.
Okay.
So what's the state's position on this?
Well, Your Honor, Ms. Prosser's here, and she's
Right there, I never did
in my
anything
ear
there.
about
I don't
wanting
know why
to
I
dismiss the charges, but we're not willing to do that today, but I don't think she wants protection.
Stand right there.
Is that correct, ma'am?
Yes.
Right, no protection order on
Don't worry about that.
the domestic, which was 24,379, no TPO at her request. I will order, here's what I will do, Mr.
Yes, sir.
Broad, kind of the opposite of what you wanted, but it can work. I'm ordering you stay away from Paul Hill. So you see him, you retreat. You go in your apartment.
Yes, sir.
He pursues you. You get on the phone, you call the
Yes,
police.
well, see, that's, I
Guy's
didn't,
here.
yeah, and that's what I tried to do. I warned him several times. The guy persisted and kept.
You know, I won't go into the details.
All right.
Not until.
Good to listen to your lawyer.
All right, thank you.
Find those two spots right there.
So you're ordered to stay away from Paul Griffin Hill. You don't post anything about him, don't go around him, don't contact him, stay away. I don't want there to be allegations of other things.
Yes, sir, I understand. I understand completely.
Okay. So now the issue is going to be when do we come back to court? He has a bond up. Mr. Broad has posted a bond. You have a preference, we're looking at probably the 23rd or thereafter.
No preference, Your Honor, but it sounds like the 23rd might be a busy day, so.
It's not that bad,
Oh, okay.
15 pre-trials so far, so that's not terrible.
Okay.
Did I say it then?
Yeah.
23rd? August 23rd will be pre-trial on both matters. Not guilty plea is entered for Mr. McBride.
Thank you, Your Honor. We got
You're right.
Thank you.
Your Honor, there's something we need to address on this. Ms. Prosser just reminded me that she's got a charge against her right now, against the domestic violence case, where,
Yeah, see, I was the
Mr.
victim.
McBride,
yeah.
I was the victim.
has she been arraigned on that?
And yes, and on June 28th, she agreed to go to counseling. So,
Maybe they both would need to go then.
well,
I've already been in it for,
I've been in counseling for 5 years now, sir.
Okay, good.
so,
When's her next hearing date?
next Friday.
You want to change it to the 23rd? Keep them both on the same day?
yes.
I can.
Who's your lawyer, man? Do you have a lawyer?
Yeah,
Roger Smith?
yeah.
Is he still here?
He left, Your Honor, I believe.
Okay, well, let's move it to the 23rd, assuming Mr. Smith can be here that day. We'll put them both on the same day.
I have a question, Your Honor.
Yes, ma'am?
Okay, I talked to my counselor, she's Raquel from Down at Contemplations. She said that she doesn't do the anger management, but she turned the report in just where I go to her every Monday. Or do you need a specific anger management?
Will she see him also?
I think he goes down there, but she doesn't see him. There's different counselors.
Okay. What's the state's position on that?
As long as she's,
And therapy.
yeah,
Yeah, okay.
and going to a place that's,
This
Has
is
the
Contemplations
credentials.
down in Cerrito.
Okay, will she generate a report? Well, I need to see a report. So what's
Yeah,
going
yeah,
on.
and I'll bring that on the 23rd. She just told me to ask because if it was just generally for like anger management, she wouldn't be able to do that. But if it was just like my regular treatment, that she could do that.
Yeah, treatment, yeah, I've been in therapy.
What I want to see is some way we recognize what the problems are between the two of you and address it so that you don't come back to court
Yeah, I
anymore.
understand.
That's what I want to see happen.
And I appreciate that because that's all I want as well, Your Honor.
We'll have a
We're on the
letter.
same page.
So I'm willing to do whatever to make it good for her.
Okay, we'll keep the 23rd date then. August 23rd will be your next hearing.
All right, thank you.
Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Kimberly Miller, case number CRB 2587. Kimberly Miller.
Kimberly Miller, Mr. Oh, this had been set previously, so there's nobody around. Hey, man, you're Kimberly Miller?
Yes.
This is an old case. My last note on this was that you got a warrant issued back in December of 20 for failure to appear and that you left treatment at that point.
I did, yes.
And it looks like you got picked up on a warrant and posted a bond.
I did, yes.
Mr. Holt had been your attorney back then.
Yes, I think the last time I had court, though, he didn't end up showing up.
Okay, well, that's been 4 years ago, or almost 4 years ago, 3.5.
Yes.
So your case is still unresolved. You had been going to Riverside Recovery, now known as RRS.
I still talk to my counselor on a regular, and I could have her write like a letter or whatever. When I left, it was like probably a week before I was going to be graduating anyways.
It was a theft offense from Walmart.
Yes, for a cortisone cream.
Okay.
And I
So
think
what I'm going to direct you
that's the
to,
mis-
where are you living now? Are you still local?
I'm in Chesapeake. I actually
Okay, that's very local.
it's very, very local.
Okay, do you have Mr. Holt's contact information?
I can get it if I need to.
We may have a card to give you. Okay, contact Mr. Holt and tell him that I have placed your case, that you got arrested, you posted a bond, and I've put your case on for August 30th for a pretrial.
Okay.
If he wants to change that date, he'll let you know, give you another date, when it's better for him to come back.
Okay.
Any questions?
No.
Okay, that's all. We'll see you on August 30th unless Mr. Holt tells you he's made arrangements for a different date.
Awesome, thank you.
You're welcome.
State of Ohio recalls Cody A. Kelly, case number CRB 18292, TRD 18628, A and B, CRA 14498, CRB 16661.
This is Mr. Morford's case.
Do what?
It had been,
What is it? K-E-L-L-E-Y?
called previously, but he's here now.
Why did you call it? Because I was coming back from Mason Venture. I had called. They told me as long as I made it here before the court ended. I tried to get on video and they said that you had to make arrangements for that. When were you supposed to be here? I think it was 9:30. 10:00. Yes.
And he does have a bond up, so that's why it's on the sentencing docket from last fall. So I'll cancel the warrant since he appeared.
I also have money on my phone today too to pay on it.
Judge indicates he has some money on his bond today.
Okay.
100.
That should probably go to, there was restitution on, well, that's the oldest case too. Looks like it's just about paid off.
What's that knock it down to, Your Honor?
$91 looks like to me, that's what it will be left on the one case.
Oh, okay. So
The
what,
oldest one.
how much is it all together?
I don't know, let's see, I'm showing 191 on that one, 410 on 18,292, 1661 was 185.
And you'll let Gary Sires know that I made it here?
I will.
Or I will if you don't.
You don't want to be looking over your shoulder all weekend?
No, sir. I was doing 100 all the way here.
I wouldn't be making that decision.
Well, that's not good. You don't have to do that.
Is there gonna be like where?
Okay, so I'll set, your next hearing should actually be a sentencing. And I'll set it for September does it matter if it's Mondays or Fridays? Are you working?
I would say Friday if you can.
All right, September 16th is your next hearing. Sentencing at 10 o'clock.
September,
16th.
that's a Monday.
I'm looking at the wrong month. Okay, hold on. Thank you, Mr. Morford.
Could we do that,
Let's make it September 13th, September 13th. September 13th for sentencing. That's a Friday.
September 13th. This year, 10 o'clock. Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Brian Montrosa, case number CRB 24499, CRB 1733, CRB 16543A and B, CRB 14593.
Okay, there's a new charge, Mr. Morford and Mr. Montrosa, 24499. A, B, and C. It's been served copies of the charges.
Yes, Your Honor.
Okay, it's resisting arrest, obstructing official business, criminal trespass. Do you wish me to read those into the record, Mr. Morford?
We waive that, Judge.
These all alleged to have happened on August 7th in Union Township. I'll enter a not guilty plea for Mr. Montrosa. He has posted a bond with Mr. Sowers. He's double bonded because he bonded on his old cases and he bonded on this new case, so. Pretrial, August 23rd.
I'm good then, Judge.
Pretrial, August 23rd, and review hearings, August 23rd. Anything else from the state?
No, Your Honor.
August 23rd is the next hearing on everything.
I'll give you it.
Thank you.
Thank you, Your Honor.
State of Ohio versus Vicky L. Price, case number CRB 24451, CRB 24470, CRB 24493. Vicky Price. Mr.
Stiers case after pretrial Looks like she has a new charge, maybe why she didn't show up.
Your Honor, based on my discussions with Ms. Price the day I was appointed to the initial charge, a couple of discussions that have happened since then, and some information provided by the state, I think at this point it's probably, I guess I can't really, I'm not authorized to do anything on these new charges with her today, but I'm going to tell you that my intention on those is going to be an enter and not guilty by reason of insanity plea and ask for a competence evaluation, and I'm going to also ask for a competency evaluation on the existing charge and seek leave to amend my plea to not guilty by reason of insanity.
It's not unexpected. And Your Honor, we have a series of incidents that I know have got these people scared. Their neighbors, and this lady's behavior is erratic and irrational and is involved in a gun on 2 different occasions. So we're kind of scared of this woman.
Yes, sir, we are.
Well, let's just have a warrant issue for her, and we get the sheriff to serve it.
Well, I would hope so.
Well,
I mean, they've gone out and they've charged her several times, so, but yeah, we think she should be in custody at this point.
Okay, and you can, the court will issue the warrant, you're the lawyer for the sheriff, can you light a fire under him to say this needs to happen?
Oh, yes, no question.
Okay. That's about all I can issue a warrant, but usually the judges don't go out and serve the warrants, so that's law enforcement that does that. So I'm just entering an order that she should be picked up. I don't think it's a secret to say whether that happens or not depends on if somebody lights a fire under it. Let's be honest, there's a lot of warrants issued. I mean, people don't show up all the time, and they're not going to go look for everybody. But if someone makes a call and says, hey, this is a special case, we think this lady's dangerous, she needs to be picked up right away, staff, maybe they'll get through, they'll send a deputy there and pick her up. So that's their job. Yes, sir?
Yes, we live in like a suburbia area. We've got several houses around us close by. There's children there, and some of her behavior is just bizarre at best.
So this is
we have a worry. We got a CPO. She broke it right away, and actually 3 times now she broke it. Other ones haven't come up yet, maybe, but we have pictures and everything on our property. And she has said that if I'm on her property, she would shoot me.
And you're Michael?
I'm Michael. She would shoot me without hesitation, without a warning shot. But then she tells Deputy Frame on another incident report that I'm on her property, that she owns my house, she owns my property, if the U.S. Marshals confiscated it, and she bought it somehow, and my cars are stolen, so is the next door neighbor's car.
Well, it sounds like we're, and counsel tends to agree with that. She's not dealing in reality, so we need to get her picked up as soon as possible.
I'm sorry.
Go ahead.
If I may, Your Honor, under the circumstances, I'm not sure I'm really authorized to accept service of these, so I'm gonna, if I may, just walk them back to add back to the file.
But she was ordered, she has a pretrial today, she hasn't appeared for that.
Correct.
So I'll issue a warrant on that. Apparently she hasn't been served with these new charges. But she did fail to appear on the previous case where she was served.
Yes.
Oh, she has a bond up too, so. I believe, let me check.
This is for samples that they want to say she was sons for the 23rd. They were going to go and give it to me.
But she had an arraignment today too, obviously.
Right, but she's never been served. This is our, I would ask the prosecutor to put a buck in the sheriff's ear to go pick her up, but also, this may work better, Mr. Sowers has a bond up and he is very responsive.
He's more motivated than the sheriff.
Yeah, so I'm going to notify him right now that she failed to appear and ask him to put carefully an extra effort into getting her into custody.
I say one other thing.
Yes, sir.
This, for the last 2.5 months, we've been living in misery with her next door to us. We have to sneak into our house. Hopefully she's not there parked beside us. If she is, we turn our recorder on, and we have to walk in the front door fast as we can. We can't even use our front yard at all. I'm afraid to go out there if I got a bullseye on my back.
I understand.
Okay,
I'm sorry you're going through that.
thank you.
So the only thing we can do to remedy that at this point is get her picked up and then deal with whatever the consequences are after that.
I'm here Monday.
Okay. I'm going to text Mr. Sowers right now and ask him to put an extra effort into trying to get her this weekend. And also warn him that she could be dangerous.
Thank you, Your Honor.
Thank you. Sorry. You'll be notified if she is, and if there's another hearing set. As of now, there's not a hearing set, there's just going to be a warrant issued until she actually comes into custody.
And if I may, Your Honor, she did contact me in the meantime. Didn't say anything, just asked me to call her. I called her back, and she never responded again.
Okay, thank you.
I knew about that too. Yeah.
I'm just texting the bail bondsman now, telling him what the circumstances are. So he's very good about picking people up, so hopefully something will happen this weekend, and you'll be notified if she is in custody, and a new hearing date set.
Thank you.
Okay, I think that's all.
Thank you.
I'll talk to you.
Yes, I'll set it for a bond forfeiture hearing for August 30th. That's 24,451. I first sent it to him. Sent it to Martin Hughes first. He said, is this meant for me? Okay, bench warrant issued on 24/4/51, and that's today, not in 7 days.
State of Ohio versus Casey Barker, case number CRA 24/458, CRB 24/404, CRA 21/614, CRB 11/849, TRD 12/2915, A, B, and C.
Did you know where the primary, did you see it in the card? Okay. Just forgot to ask you.
And what day is the,
August 30th. Wrongful.
Your Honor, I believe we have 2 current pending cases here. We have a misdemeanor, the first degree domestic violence, and we have an F3 domestic violence. My understanding is the state's intention to present the F3 to the grand jury in order to preserve his bond. Mr. Barker is willing and ready to waive his right to preliminary hearing on that matter. Regarding the misdemeanor, it is a separate alleged incident, so it would not travel with the felony. I don't know if the alleged victim is here today, but she has appeared in the past and said she is not interested in pursuing that charge. I don't know what the state's position on that is going to be. But as far as the felony goes, we're prepared today to waive preliminary hearing.
Okay, well, let's get that out of the way, then we'll deal with that. So he's going to sign a waiver. Mr. Barker, what you're saying is, I agree my case can go to the grand jury without me checking to make sure there's probable cause for it to happen. That's what the preliminary hearing is supposed to be. So you're agreeing we don't have to have that hearing. It's going to go on to the grand jury. And you're doing that to keep your bond, because otherwise I think they would just nolly it, which means dismiss to the grand jury, and then you'd have to post a new bond.
Right.
Once you got to common pleas.
which case number, Your Honor?
24/458.
Is Carolyn Barker here?
No.
This is a nolly.
I'm sorry. Okay. Give me 1 second, I'm still at 50 Price.
Sign here, please. Thank you. May I approach?
Yes. All right, so Mr. Barker has signed a waiver on 24/458. So that case will go down to the grand jury. It's bound over. he still has a misdemeanor, and he's got old cases too that he had review hearings on, but the case that's pending is 24404. That is still pending, and it is a domestic violence from June 26th of this year, involving Carolyn Barker.
And Your Honor, Carolyn Barker's been here a couple times, if the court remembers that she was adamant that she didn't want the charges pursued. And so what we would do on that one is nolly it with the right to refile it. And then that, I think that takes care of everything that's pending, at least current.
So it's not only due to request of the complaint party.
Yes.
That's 24404 is nolly. So then the only things that are still pending are 21614, 11849, 122915, 11349. These were all old cases that they're still, looks like just fines. I don't see any service or big community service.
I can, yeah.
Still fines and costs. That's all that's left. So you have a payment on his old cases?
He says he can make a $20 payment today, and he can begin to make monthly payments.
Okay.
I don't know if the court, at this point, we're going to keep it on the pretrial docket for a little longer to get time to get something established. We're going to return to the review docket.
Return to review docket.
Okay.
So he can make a payment to the clerk today.
Yes, Your Honor.
Set it a month out for the next review hearing. It's a matter if it's Mondays or Fridays.
It does not.
September the 16th. September 16th will be his next hearing.
And this will be at the 9 o'clock review hearing.
Correct.
Docket.
Yes.
So you'll be here at 9 on the 16th. If you have everything paid off, then you would need to come.
See the clerk to make a payment on his old cases.
Show the progress. I'll keep showing progress. He'll keep working with you. All right. Thank you. Yes.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jonathan T. Register, case number CRB 24159, A and B. Jonathan T. Register.
It's Mr. Steyer's case.
When I last checked with the front desk, Your Honor, he had not checked in.
And it's on the sentencing docket.
Yes.
Yeah, apparently he has a bond. He does have a bond that he posted in March of this year. Let Mr. Sowards know that he's got another one in the process. So there'll be a bench warrant issued today. Bond forfeiture August 30th.
State of Ohio versus Jermaine L. Smith, case number CRB 24380.
Mr. Steyer's case set for pretrial.
And Your Honor, Ms. Maxey, who is the alleged victim, she's misnamed Smith on the document, but her name, my understanding is her name is Maxey, is here, and I believe has spoken to Jasmine about the case. It's my understanding she doesn't wish to go forward with the case. I I don't know what the state's position on that's going to be, but at the very least, she is asking that the protective order be withdrawn.
Yes.
Well, if she wants the protection order withdrawn, then obviously we don't have much to say about that.
What's your last name now?
Maxie.
Maxie, okay, that's what's on the affidavit.
We move to amend that on the complaint, Your Honor.
No objection.
All right, it'll be amended to, it's M-A-X-E-Y?
Yes, sir.
How's the state want to proceed?
Well, Your Honor, and we respect Ms. Maxey's opinion about this, but in reading what, in her own words, happened,
It's pretty serious
it's
stuff.
very serious. And I have to hear something incredibly, you know, in order to paint a picture that did not make this look really bad. I don't know what it would be, but we can't just dismiss this case.
Okay, so what would you like to see happen, Mr. Hill? Why don't you lay something out there?
Well,
Or something?
we think that and here's the thing, you said these things, right?
I was also intoxicated.
Okay, well, your handwriting looks pretty clear for an intoxicated person.
Are you a DRE, Mr. Hill?
No, but I've got experience in intoxication.
You win that round.
Because of Ms. Maxey's feelings about this, we understand that if he were to enter a plea of guilty, we would recommend a suspended jail sentence of 30 days. Today, that would be our offer.
We're not able to do that, Your Honor. Something was discussed earlier, it was the possibility of a 90-day continuance and payment of court costs if there were no further problems, and dismissal at that point. That's something we could entertain if the state would be willing.
I just have a feeling the judge wouldn't like that.
I would say, how about some counseling? I mean, this,
I'm already in class. I go to ADS.
this behavior is not, if this is true, what she wrote in the affidavit, it's totally unacceptable.
Provide something saying to
I got it in the
Way out of bounds.
provide something they can report to the court. Okay, he is in treatment, Your Honor, and is willing to execute an authorization to allow records of that treatment to be provided to the court, counseling. So that was something we could add into if again, a 90-day continuance would be a possibility.
All right, Ms. Maxey, are you, because I assume, it doesn't necessarily, yeah, I think you do say my boyfriend. So is this still a romantic relationship, or what's your relationship?
No, sir, that's my daughter's father, but
Oh.
we're not together.
I haven't seen my daughter since the protective.
Well, this says, I was at a pool party and I had my boyfriend come pick me up.
Well, at the time, we was together, but we're not anymore.
I said, now back up, you said this is my daughter's what?
He's my daughter's dad.
Oh, okay. So you have been, it has been a relationship?
Yeah,
But you're saying that's no longer the case?
yes, sir.
Was it because of this? I mean, it should be a deal breaker. It should be a deal breaker. Was that a deal
It was
breaker?
more than just this.
I think this is.
It wasn't working.
This is enough. In my opinion, this is plenty
Right.
to be a deal breaker. But here's the problem for me. I don't want to see him doing this to somebody else. And he's still a young, I mean, everybody's young compared to me now, so he's still a relatively young man. So he's gonna have other relationships. He needs to know this is not acceptable. This is not the way you treat people. You agree with that, don't you?
Yes, sir.
Well, how am I going to, if we don't do something about it, how am I going to, 2 years from now, if this happens to somebody else, and maybe they get a worse result than you did? And they're going to be looking at me saying, Judge, why didn't you intervene here and try to straighten this guy out so he wouldn't treat people like this? Right? So that's why I want to be convinced this isn't going to happen anymore. So about the only way I can say that is that we have him do some counseling, and as he reported this to his counselor, he needs to give them, you know, an honest assessment of what happened. I mean, you're bigger and stronger than most women, 99.9% of women. You can't impose your will on them with threats of violence and violence. So we need some way to show he understands that, and it's not going to happen anymore. Or we just set it for trial.
He's indicating he is in counseling twice a week. Mondays and Wednesdays. He is, again, he said he's willing to sign paperwork to allow reports from the counseling to be provided to the court. He is willing to pay.
What's he in counseling for this?
Domestic violence.
Okay.
Domestic violence counseling.
Were you required to do that by?
On probation, yeah.
He's on probation. It's a term of his probation.
What court is that?
They got federal probation.
Oh.
Yeah.
Do they know about these charges?
Yes.
You don't want to mess with those people.
Okay.
They don't play.
This kind of ups the ante a little bit. If that prior involved violence, domestic violence, this really rightfully should be a domestic violence charge. This could be a felony. So there's a lot at stake here for Mr. Smith.
Is that United States District Court, Southern District of Ohio?
Yes.
Of Columbus?
Yes.
Okay.
We're okay with
that. That really does raise the ante a lot.
Yeah.
So I think he, I think he needs to furnish his reports to the court, and I'm going to direct my probation officer to contact his probation officer at the federal court in Columbus and tell him what's going on here.
Yes, Your Honor.
And furnish him a copy of the charges in the affidavit.
Yes, Your Honor.
And they may already have it, but I want to make sure they have it. Okay, so 6 weeks come back approximately?
Your Honor, 6 weeks puts us early October. I would ask if we could do a Friday because of, as he mentioned, he does his counseling on Mondays and Wednesdays, so a Friday would be best. I'm available October 4th. The 11th, I actually have a jury trial scheduled at the moment, but the 4th I'm available.
October 4th will be the next hearing. Okay, Mr. Major, you heard that, so if you can do all this, it shouldn't be too hard to find.
Yes, Your Honor.
The federal probation office, give him his name, send him this information.
Melissa Menard, she already knows.
I'm sorry.
Her name is Melissa Menard.
The name of the probation officer is Alyssa?
Melissa.
Melissa Menard.
Melissa Menard, okay. Thank you.
And just to be clear, has the protection order been withdrawn?
Yes, I'll withdraw the protection order at her request.
Thank you.
State of Ohio versus Ronald Spears, case number CRA 23611.
Mr. Morford's case after pretrial.
Judge, I'm gonna have to ask you for a short contingent. Somehow we omitted to do discovery. I have it with me here and filed suit today.
Okay.
What is he?
Mr. Spears wants to see the video of the event before we decide how to handle this.
All right, how long do you think it'll take? Well,
I've got it ready to serve now.
okay, so it's going to be August 23rd or after. What's best for continuance?
I'm good through the 13th.
Does it matter if it's Monday or Friday for him to come
Not
back?
for me, Judge, no. You know, I'm here most Mondays and Fridays.
Let's do Monday, the 26th, August 26th. Be a pretrial then at 10 o'clock.
Thank you, Judge.
You're welcome.
State of Ohio versus Jacob Little, case number TRD 24-1400 A and B. Your Honor, he's on the sit.
Okay, Jacob Little is a pretrial today. He's attending by teleconference. He's on a driving under suspension and some kind of light problem on the back end of your vehicle. Are you trying to get your license back, Mr. Little?
Yes, sir. I do already have my license reinstated to the state of Colorado. I do have paperwork from the state of Nebraska, state of Iowa, saying that they sent over a notice of withdrawal on the 20th of May here, and that information was never accepted or processed through the state of Colorado properly, leading to the result of the suspension of my license.
Do you think it's been processed now?
Currently, yes. Yes, I did have it in process now under my supervision and attendance of the court in the city of Colorado to cure this issue with paperwork.
Okay, well, what we can do, I can have someone check that.
Absolutely, and if need be, I'm more than willing to have either the state of Iowa and or state of Colorado be able to fax that information over to you guys, however, or email, fax, or anything.
Okay, I'm going to have one of my bails check. Do you want to reschedule this, or you want to just stay on the line until they check it and come back?
However you need this, sir.
Okay, why don't you just stay on there? I'll have them run this, and then if your license was reinstated and shouldn't have been suspended, I'll dismiss that charge. So just hang on.
Yes, sir.
Ready to go to the Lawrence County Jail, Your Honor.
Okay.
State of Ohio versus James Eastman, case number TRC 23-1864, A, B, and C. James Eastman at the Lawrence County Jail.
All right, sir, you're James Eastman. Okay, your audio is turned off on your headset, Mr. Eastman, but you're not coming through.
There, do you hear me now?
Yes, I can now. Now you're coming through. All right, Mr. Eastman, it's alleged that you had a pretrial on February the 9th of this year on the main charge was operating a vehicle intoxicated, that you didn't show up for that hearing. And when you didn't show up, you got a warrant issued. So that's why you're in jail now. Do you understand the charge? Do you have an explanation or about not appearing in court February the 9th?
Yes, Your Honor. I was supposed to be getting an attorney, and I didn't have $6,000 to give an attorney. And so I was going to be coming down and filing guilty on it. But I only had one vehicle at the time, and it blew up on me. And so nobody else wanted to drive all the way down here. I only had one other person that was willing to drive down here, but they used my vehicle. And I had just reacquired a vehicle, and they took and impounded that on Tuesday when they picked me up at my home county. And so I've been in custody for 4 days.
So were you picked up in Franklin County?
No, Madison.
Madison?
Yes.
Okay. Well, did I hear you say that you wanted to change your plea?
Yeah, I was going to plead guilty because it was just M1.
Well, you got a prior though, so,
I thought that was over 10 years.
well, you got one in 2016 according to the complaint. Let me check your file here. The state probably should pull your file on this because he's wanting to plead guilty and it has multiple prior ODIs. I don't know if you have it.
This is Jacob Little?
James Eastman.
Oh, sorry.
And it's not on the docket, probably not on the docket because he had been on the docket back in February, failed to appear for a pretrial, and then he got picked up on a warrant, and now he's in jail on that warrant.
Eastman?
Eastman. The case number is 231864.
TRD?
TRC. With a prior in 2016, 2011, and 2005. With a BAC of 147. Okay, so if you enter a guilty plea, this is at least a second offense. It looks to me like it would be a second because he did take the test. So the look-back period, I believe, would be 10 years. So it would be a second offense. The maximum is 6 months in jail, $1,625 fine, and a 5-year license suspension. The minimum on a second offense is 10 days in jail, $525 fine, 1-year license suspension. If the vehicle is titled to you, there's required an impoundment required also. I don't know what happened to the vehicle in this case. Let's see. It looks like it was titled to you. Did you ever get your vehicle back, or where is it?
The one that blew up was the one that I got pulled over in, and it's already gone to the scrapyard.
Okay, so
It was, I got it back at the time when I was released.
okay, well, that probably shouldn't have happened. But in any event, so that's where you're looking at it. If you plead guilty to this charge, you're looking at a minimum of 10 days in jail. That's the mandatory minimum sentence on it. Do you understand that?
Yes, sir.
You still want to enter the plea?
Yes, I have not been able to get a hold of anybody in contact up home at all since this has all occurred.
Do they know where you are, or you just disappeared?
Nobody knows where I am. I got a hold of one voice.
They may think you got raptured or something.
I don't know. So, if there's a way.
Rapture of one. You're the only one worthy of going.
What's that, sir?
That's my attempt at a joke. So anyway, are you working?
Yes, sir. I work a full-time job.
Okay. All right, well, you're sure you want to enter a guilty plea to this charge?
Yes, sir. I just get this over with, and if I can schedule to finish up my days.
Well, you can, but then you'll have to start over. If I sent you now, I can give you credit for the amount of time that you've already served. But because the legislature says it has to be consecutive, there's no breaking it up. So,
Okay. Well, if I can schedule the jail time and come back down and stay.
okay, you can, but I want to make sure you understand what I said. You got to start over. You know, you don't get credit. You said you've already served 4 days. That 4 days isn't going to count toward whatever you get because it has to be consecutive days.
Okay.
All right. Anything else you want to tell me?
No, I need to get this squared away, but I was going to be getting in contact with you and get it squared away. They pulled it over this week and I got picked up, so.
Okay, well, let me read the officer's report into the record because I don't know anything about your case. So I've got the officer's report that says December 23rd, At 3:37 a.m., I was on patrol of US 52, milepost 17, village of South Point. I witnessed South Point Police Department on a traffic stop. I stopped to assist. When I approached the passenger side plate view, there was a case of Miller Lite and open containers around it. Patrolman Perky advised he initiated traffic stop due to license plate being expired and not matching the vehicle. I asked him if he would be okay with me speaking to the driver. He said yes. I approached the driver's window. It was James Eastman II. He said he was on his way to Florida from London, Ohio. As I spoke to him, I observed his speech to be slurred. When telling me about the reason for traveling, he said, "It's Christmas and my sister and brother-in-law and my mom live down there." He also said he worked near Jeffersonville. His eyes were very watery and bloodshot. I detected an odor of alcohol coming from the vehicle. Asked him if he had been consuming alcohol. He said he had had a couple beers. It had been a couple hours since he had consumed any. I ensured that Patrolman Perky had concluded his extent of his stop, asked if I could continue pursuing my encounter. Mr. Eastman, to see if he was safe to drive. He told me I was free to continue, so I asked Mr. Eastman to exit the vehicle. He went to the front of my patrol car. I gave him the standard field sobriety test. He had several questions, and I asked him about his ability to perform tests. He said he did not wear contacts or glasses. He said he was taking medication that was amoxicillin. He said his left knee was bad, his right ankle was swollen. He said he walked with a cane. He was not experiencing any dizziness at the time of our interactions. I could still detect an odor of alcohol coming from his person outside the vehicle. Gave him horizontal gaze and nystagmus and got 6 clues for impairment. I asked him if he could do the walk and turn. He said he does up and down ladders and crawls under tight areas as part of his work. His speech was slurred while describing his work activity. I gave him directions on performing walk and turn. He started doing it before I told him to. Told him to stop and try to reset. As soon as he stood, as I had asked him again, he began the test over, asking if he heard what I was saying. He said, yeah, and continued to walk. I told him on the third attempt, his steps down the line had to be heel to toe. On the way back, almost all of them were not heel to toe. He used his arms for balance. He had 3 validated clues on the walk and turn, 1-leg stand, put his foot down for balance, raise his arms, sway. I gave him portable breath test, and that showed a test toward 149. Placed under arrest for OVI, given Miranda warnings. There was cold Miller Lite, opening the front passenger floorboard. Taken to the patrol post, agreed to give BAC test, tested 147. Okay, that's pretty much the report. Anything you wish to say, Mr. Easton? No, sir. State take any position on sentencing?
No, Your Honor. It's a second offense, so standard treatment, I guess. And if I wasn't really aware of what his reason was for not being here for a period of time. If that's a reasonable excuse, I don't guess it deserves anything extra.
Well, I think really didn't have much of a reason. It's been since December. It's not like he missed last week and got here today, so. Okay, I'm going to give you a $750 fine on your ODI. I'm going to give you a 1-year license suspension that started the date of your offense. I'm going to sentence you to 30 days in jail. And I'll give you credit for 4 days served. I'll suspend 11. So I'm going to require you to do 15 days of jail. So I think you got to do more than what you would have done for somebody else that gets a second offense on December 23rd and comes to court when they're supposed to, should get less of a penalty than you get. So you're getting an extra 5 days in jail because you didn't come when you were supposed to come to court. Also, I'm going to make you do more community service. So normally it would be 60 hours of community service. I'm going to make you do 90 hours of community service. I have to order you to get alcohol counseling. That's going to be part of your sentence. That's required on a second offense. And it's indication that alcohol is your issue. So you got to show me proof of alcohol counseling. Do you have health insurance, or how do you pay for medical services?
I don't have any insurance.
Okay.
And I just went through one of the courses last year.
Okay, well, you'll have to do it again. That's required under Ohio law. If you get a second offense, you got to go to counseling. So you'll have to you either have to pay for it yourself, or maybe some agencies have some ability to pay basis. I'll let you do that in your home area where you live, but you're going to have a review hearing here. I'm going to put you on 2 years of level 3 probation. We'll make it level 3. I'll set your first review hearing in a couple months, so that's going to be October the 11th at 9 o'clock. I want you to, we can have Mr. Major call down and talk to him.
Yes, sir.
So I'm going to have your probation officer call the jail, talk to you, because you're not going to be here to talk to him. Have him call, talk to you, and get some contact information. Is this address on your ticket still good? 769 US Highway 42 Southeast, Lot 15, London.
Yes, sir.
Okay. Do you have a phone?
Yes, sir.
What's that?
614-420-5822.
Is that a cell or a landline?
That is my cell. That's the only phone I have.
Okay. Then on the safety belt violation, that's a mandatory $30 fine. Failure to register, expired tags, $30 fine. So those are $30 fines. All right, so you'll get discharged after you've been in there another 11 days. You got to do 11 more days. Give you credit for what you served before. And Mr. Major will call and talk to you about your probation at some point. Any questions of me?
So, am I going to be able to schedule the following days, starting, or are you just going from the day on?
Well, if I let you out, you're going to have to come back and I probably will make you post a bond because you didn't come before. Can you post any kind of bond to guarantee your appearance? And you'd have to start over or do 15 days. Now you've already got 4 days in.
Well, I have nobody knows where I am. And I'm not certain what's going on, and I need to get home and get things straightened out up there. If I can.
Well,
Because I need to because they took my new vehicle up there, and I don't know where it is.
so have you got charged spending in your home area too?
No, I didn't get any charges. They just took and towed the truck.
When you got arrested?
Yes.
Well, can you post any kind of bond?
I don't have anything on me as far as, and I don't know who to call.
Okay, well then I'm not going to let you out because I don't trust you to come back.
Only thing I've got is title for my truck as far as collateral.
Okay, well, I'm not interested in that. So you'll
Well,
you'll have to stay in jail. You'll have to stay in jail. That's part of the consequences of not showing up.
Okay, well, that's the only thing I've got is my truck title, and I actually have that with me here, so if I was able to do any bond.
State of Ohio versus Monica Gibbs, case number CRA 24439, and Virginia McGlone is on deck.
He's got 11 more days at our jail. Give him credit for the 4 he's spent in transit to get down here. Okay, this is Monica Gibbs, Mr. Morford's case. It's a preliminary hearing. She was at Bethesda, but I think she went back to the victim. Yes. Okay, she was discharged for non-compliance at treatment at Bethesda, and that's documented in a letter dated August 7th, sent to the court. This is and her bond was revoked. She has a felony, so what's the state's position on it?
Well, it was our intent
Felony theft, it's not a felony possession charge, it's a felony theft offense.
right, and our intention was to offer a misdemeanor on these, and for her to be compliant in treatment, and there wasn't any restitution, even though the amount of the theft was over $1,000. But under the circumstances, I guess we're going to have to go a different direction unless Mr. Morford and Ms. Gibbs have a different idea. We're going to need to have a preliminary hearing unless she wants to waive to the grand jury. But we're not prepared to have a preliminary hearing today.
That's, I have a chance to call her.
Sure. All right, Ms. Gibbs, I'm going to let your lawyer, Mr. Morford, call. You have the report from Bethesda, Mr. Morford?
I do.
Okay. I'll have you back on teleconference after you talk to your lawyer.
Thank you, Judge.
You're welcome.
State of Ohio versus Virginia M. McGlone, case number CRA 24498 A and B, and Billy McKenzie is on deck.
Are you Mary Brooms?
Yes, I am.
Yeah, you talk to the prosecutor. All right, ma'am, you're Virginia McGlone.
Yes, sir.
Can you hear me, Ms. McGlone?
Yes, sir.
I'm Judge Capper. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do make statements that can be used against you, you have a right to have an attorney, to have one appointed for you if you can't afford one. You have a right to bail, to make the state prove these charges beyond a reasonable doubt. Do you understand these things?
Yes, sir.
You're charged with theft and possession of cocaine. Those are the two charges. The theft offense alleges, and that's 498A is the case number, alleges August 7th of this year, you purposely tried to deprive Mary Grooms of property being $420 from a bank account that he had no right to obtain. Excuse me. Mary Grooms is the owner and authorized as the only person to give consent. So that's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. 498B is the possession of cocaine charge. It alleges that on August 7th, you knowingly obtained or possessed or used a controlled substance, and that controlled substance was cocaine. That is a felony 5. Maximum penalty is 1 year jail, $2,500 fine. Do you understand these 2 charges?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
No.
All right, Mr. Stratton, I'll point to you. What's the state's position on bond, and how's the state want to proceed with this?
Your Honor, Ms. Grooms is here, and she is Ms. McGlone's mother, and this is not the first time that Ms. McGlone has stolen money from her mother's bank account, according to Ms. Grooms. I guess it's the first time it's been reported. It's a pretty serious situation. She says that her daughter has a serious drug problem and is in need of treatment and would not do it unless her arm's twisted. So if she wants to get out of jail, we would want her to be evaluated to be in a residential treatment program, which sounds as if she would qualify for that.
Okay, so what I'm going to suggest, and I'm assuming, you didn't say this, but I'm going to assume, because it sounds like the main thing the family wants is for her to get some treatment, that if she is successful in treatment, you keep it in this court and be willing possibly to dismiss the charges if she's successful in treatment. Is that correct, Mr. Hill?
I believe, based on what we see right now, and I don't know how it's going to work out with her repaying her mother, she ought to, but yeah, we want her to get treatment.
So, Your Honor, I think treatment and the way we'll handle this is she'll definitely doesn't want to be in jail, I'm assuming, so she'll probably go to inpatient, willing to go to inpatient, and then if she does well, we'll treat it as we typically do.
So, Ms. McGlone, do you understand what's being offered? Treatment is basically what's being offered to you. Or is that something that you are willing to do? Do you want to talk to your lawyer about that before you make a commitment to go to treatment?
No, sir. I'll absolutely look at I'm running an outpatient. It's not that I'm addicted, I mean, I'm an addict, obviously, have been for many, many years. I don't know a lot about that. And the cocaine was something that I'm not addicted to, but I'm addicted to other things. And I have been probably 23 years of my life. I also work in recovery, so it makes it hard for me. But yeah, because I am an outpatient now, and if I can remain in their inpatient program, they would likely take me. That's in that Portsmouth area, that's where I have to be closest to. I have nobody else up this way.
Okay, well, I've just been told there's a fly in the ointment on this. She has a warrant outside of the county.
I do, yes, just Coder Superior, sir, yes.
So I'm not going to be able to do anything until that's dealt with, which means you're going to have to go to Scioto County and deal with your warrant before the judge down there and get whatever orders they do for you in that court. Is that a common pleas or a municipal court? Do you know?
It's a municipal, and I'm asking for the same thing for the same treatment facility.
What's the treatment facility you're wanting?
It's Sunrise, it's Sunrise, sir.
So that's in Scioto County.
Yeah.
Your Honor, if you would recall this case, I can check out that Soda County warrant real quick.
Okay. I'm going to let your lawyer do some investigation. He may talk to you, or he's going to call and check on the warrant, and then we'll have you back and decide how we're going to proceed here. So,
All right, thank you.
you're welcome.
State of Ohio versus Billy E. McKenzie, case number CRA 24-497 A and G, and Ronald Rimney II is on deck.
That's the only way you should commit to this. Call it out a little bit, we'll see what he decides, okay? Yes, I understand. Thank you. Yeah, don't leave.
So are you Billy McKenzie? All right, Mr. McKenzie, your charges were faxed to the Sheriff's Office this morning at 10:50, so an hour and a half ago, approximately. So you should have them. If not, they're there at the jail. You're charged with a theft offense from Oh, this is also the same co-defendant, looks like. All right, so let me go over your rights with you. You have a right to remain silent. You don't have to say anything. You do make statements that can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state prove these charges beyond a reasonable doubt. You understand those rights?
Yes, sir.
You've got theft offense and a possession of cocaine charge, both. The 497A theft offense alleges on August the 7th, you purposely deprived Mary Grooms of property by taking monies from her bank account without authorization. That's a felony 5, maximum penalty is a year in jail, $2,500 fine. 497B alleges that on August 7th in Perry Township, you knowingly obtained, possessed, or used a controlled substance, that substance being cocaine. It's a felony 5, maximum penalty, year in jail, $2,500 fine. Do you understand these two charges?
Yes, I do.
Do you understand your rights?
Yes, sir.
Do you have the money to hire a lawyer?
No, I haven't right now.
I'll appoint Mr. Steyer to represent you.
Okay, we're pretty much find out more, we get back to paper. I'm in our paper right now.
We'll get your lawyer in here and then we'll talk about it. Mr. Steyer, I'm going to appoint you to represent Billy McKenzie. He's got two felonies, possession of cocaine and felony theft. And there is a co-defendant.
I believe there may also be a warrant from Sauter County.
Okay, and apparently he also has a warrant from Sauter County. She does too, the co-defendant. So, Mr. Stratton is checking on the warrant for McGlone as the co-defendant. We think has a warrant out of Sauter County. If there is no warrant, what's the state's position on bond? Is Mr. Stratton available?
He was out in
the restroom, Your Honor.
Okay.
Sorry, Your Honor.
That's okay. Do you know anything about the warrant situation?
It's a warrant on complaint, filed 7/15. I thought it might have been a warrant on a on a probation or something else, which I could have taken care of, but apparently she needs to
Here.
yeah.
Okay. You probably, so you wouldn't know about this gentleman. He may have something there too. This is a co-defendant.
I think I know Billy McKenzie. I think I've represented him before.
Inside of county or?
Yeah.
Are you here Monday?
I'm here Monday.
I'm here Monday. Maybe we could just set it for Monday. That way, what's the state's position on bond? I guess start with that.
Well,
He has a holder from Sauter County.
Right. So if a bond is set,
No,
Oh, he doesn't?
he does not. It
Okay.
says booking record only shows local charges.
well, in that case, then, Your Honor, I would ask for an OR bond.
And I would be good to go, and then Monday or whatever, and keep it, whoever needs to keep it back on the right back.
All right, just a second,
The
sir.
only way I agree with that was if an ankle monitor go to inpatient treatment.
that would be our recommendation.
Do you have a medical card?
Yeah,
Ohio?
yeah.
Okay,
Counseling center?
that counseling center, yeah. Would you be willing to go into treatment if we could get you in?
Yeah.
Now, as a practical matter, it's probably gonna be Monday before we can get an ankle monitor onto him because of being Friday at 1 o'clock. However, we don't necessarily need to come back that quickly unless that's what the court prefers. With the co-defendant having a holder, I didn't know if you wanted to come back quickly on that one or what.
We do, Your Honor. I don't know how we're going to take care of the Soda County case unless
She'll have to go there.
Yeah, I don't know if they'll transport her there for that, or if you...
Well, I think as long as she's being held here, they won't. So that's why I was saying we want to do something quick on this one to get.
And we may determine that we would do an OR bond here to let her go to Scioto.
You want to set them both for Monday then?
Yes.
So it gives you more time to think about that. Okay, we're going to set Mr. McKenzie for Monday. I'll be looking at him going to the counseling center, and we'll put her, if she goes someplace, we'll put her in a different facility.
And I would like to ask for you to go ahead and speak to him if you could, so that when we get here Monday, that we can have a plan in place.
Now, here's going to be the other requirement, Mr. McKenzie, make sure you understand that. I'm going to put an ankle monitor on you, a GPS monitor. So what that means is, if you decide to leave, we'll know exactly where you are, and you'll be picked up pretty quickly. If you cut the ankle monitor off, and you need to listen to this very carefully, if you cut the ankle monitor off, you will automatically go to prison. Well, not automatically, but it's almost automatic, because there's not, everybody that, let's just put it this way, everybody that's cut an ankle monitor off is going to prison.
That's correct.
So, do not cut your ankle monitor off. And if you think, I'm going to be tempted to cut this ankle monitor off, you'd be better off just saying, no thanks, I'll sit in the jail. Don't put me out on an ankle monitor, because the Common Pleas does the ankle monitors, and they get really upset with people cutting them, and you'll go to their court, and they will send you to prison for cutting the ankle monitor off. Okay. Everybody says they understand, but some still cut the ankle monitor off. Even after I've told them, they still do it. Okay, so I'm going to put you on the docket for Monday, which is the 12th, for a preliminary hearing, but it will not, the state doesn't have to have its witness here, because it's just going to be more of a review. Hopefully, yes.
It depends on availability, but it's much more likely to happen on a Monday than it is on a Friday.
At this point, I'll set a $10,000 cash or surety bond, assuming he can't post that. I don't want him to get out. So we'll see you Monday. We'll try to get an ankle monitor in place. Someone from the counseling center is going to call you or come and talk to you to do an assessment to make sure you will meet criteria for treatment, which it sounds like you will. And then you got to take this seriously. Here's the thing. If you don't take it seriously, you could go to prison. There's several ways you could go to prison. One is cut the ankle monitor off. If you want to go to prison, cut the ankle monitor off. You will go to prison. Guaranteed. I'm not lying to you. Here's the other way. Don't do your treatment. Mess around in treatment. Don't take it serious. You could get sent to the Common Pleas then, and then the Common Pleas judge can send you to prison.
Right.
If you do things the right way, take this as an advantage, not as a negative thing, but as a positive thing. I'm going to get clean and stay clean. You can get your case dismissed. It's going to be way down the road. It's not going to be next week. It's not going to be next month. It's going to be a long time from now. But you can get your case dismissed if you get clean and convince me that you're going to stay clean.
Okay.
You understand?
Yeah.
Okay. I'm going to see you Monday. And I don't know if Mr. Steyer, do you want to see the file now, or?
If you're done with it, yeah, I'll copy it to have it.
Okay.
Ready to go.
Next hearing is August 12th, 10 o'clock.
Monday.
I will see you Monday.
Okay.
Yeah, great. Who's our lawyer? Okay, stay there. I think it may have been, okay, Vicky Price is getting picked up. No, you said it wasn't signed. Who's fired?
Sorry.
I'm pretty sure what, because I'm now remembering saying he was going to call, not guilty by reason of insanity.
I don't know. Your Honor, that other case, McGlone, Virginia
Yeah.
McGlone, were you going to recall it and set it
Yes.
for Monday, or is it just?
I think we'll just set it for Monday, but you want to recall, let's do
No,
this one and we'll recall.
It doesn't matter to me. That's-
We'll have to figure out how, if you want to get her to Scioto County, we'll have to do an OR or something.
We can
Yes.
do an OR with the requirement that she go to treatment inpatient and go ahead and release her, and I will let Portsmouth know.
Okay, she's up, let's go ahead.
Sorry.
State of Ohio recalls Virginia McGlone, case number CRA 24498, A and B, and Ronald Remy is on deck.
So, Your Honor, she has a warrant on complaint out of Sauter County.
Do you know what the charge is?
I believe it's theft.
Okay.
There was 2 charges. I don't remember what the other charge was. This is failure to appear in theft, I believe. This one is a failure to appear. No, it's municipal court. So it's in Judge Mallory's court, so next week is Judge Mallory's week. So if we can get it taken care of next week, if not, he won't have court the following week. They switch off.
Okay.
That's
a good idea. Can I do that?
Well, we have to
Just come every other week? I like that.
Well, I mean,
I'll second
They
that.
have another judge?
yeah, Judge Kegley and Judge Mallory, most of their cases only set every other week. But Judge Mallory's is next week. I'm there Monday.
So if it wasn't next week, would they make them sit the whole time until?
Yeah. Yeah, so Judge Kegley's case, if she was Judge Kegley's, she would set until the following week.
They have a much nicer jail.
Okay, yeah, they got a fairly new one.
Well, I would say it was nice, but it's newer, let's put it that way. But anyway, what I was going to say is that if we give her an OR bond with the requirement that she goes to inpatient, that will release her to Sauter County, that way she can.
Well, they're not going to release her on OR, are they? Is there a way that we can communicate to them that we want her back if they're not going to?
Actually, what I'm going to do is I'm going to text Eric Brown, Judge Mallory's bailiff, and tell him that she is supposed to go to inpatient, so when they arraign her on that charge, they'll make that a requirement in their court also.
Okay. Mr. Hill?
Well, all that sounds great. I can just imagine that there are things that could happen to keep that from actually occurring. I guess what I would want is for her to, if she's not in the custody of Scioto County in the municipal court, that she either, I mean, I don't know how we get her to treatment from being in the Scioto County jail.
Your Honor, Levi Morgan, who I'm very familiar with, Chief Probation Officer at Municipal Court, he is very good about getting people into treatment in Sauter County.
She's never appeared there then?
She has never appeared there, no.
This would be the arraignment?
This will be arraignment, and Levi will handle getting her into treatment. That court will follow this court's direction in putting her in treatment. I'm confident in that. Eric Brown and Levi Morgan will make sure that she goes to inpatient.
Or being, she knows to be by person.
And they'll be okay with that.
If there were a holder on her, a warrant, so that this court would have control over that, I don't know.
Well, how we can do that and let her go at the same time? Can we just send her there without releasing the holder?
I don't know that.
Can I be put into treatment by Monday? I mean, that's my appointment, again, at 1 o'clock. Is that possible? We put in an inpatient on Monday? And then
It would be, but you've got a warrant out of Scioto County that's got to be dealt with.
Yeah, I'm aware.
I can't release you to treatment at this point. Unless
Okay.
they would withdraw their warrant and say she's got a felony here, will you release her warrant so we can send her to treatment here, and then
From my experience, Your Honor,
they will do that?
I have not known Judge Mallory or Judge Kegley to withdraw warrants without an appearance.
Okay.
If the court granted her an OR bond today, and then we would set her case here for a week from today, and if she doesn't appear, then a warrant would issue.
No, I don't appear, sir.
And then in the meantime, she's gone to Scioto County.
Okay.
And I will text the bailiff right now if that's what we'll do. And
The only thing is, if they're done with her before next Friday, then there still wouldn't be, she'd have the obligation to show up here next Friday.
Right.
Or take herself to treatment.
Your Honor, I don't even believe she'll be released.
They'll order her treatment, you know?
Yes.
Okay.
And we can.
And I would prefer she not go to the counseling center because her co-defendant's there.
Yes, hometown is willing
Okay.
to.
And they'll use hometown also?
Yeah, since we're using it up here, they're pretty good about that.
Okay, ma'am, so I'm going to take my holder off of you so you can go to Scioto County next week sometime. But if you're in custody and they send you back to the jail, then I'll see you that way. If you're out of custody, then you have to get to court in Chesapeake on your own a week from today, which is the 9th. I'm sorry, today's the 9th, the 16th.
The 16th, okay.
August 16th is your next hearing. I'm ordering you to hometown for inpatient treatment, not outpatient.
Okay, now may I have a problem that I was an employee for hometown, sir. I'm a substance abuse already, that's what I was trying to let you know. I work for hometown, so I don't know.
How long ago was that?
4 months ago. I'm not real certain. I mean, I know, the rules and all, I mean, I know what, needs to be done. I just don't know if it'll affect me because I was an employee of it. Rather than that, I don't have any problems anywhere else. I work for Cardinal as well with it.
There's a representative from hometown here. Do you know if that's a problem? Or?
No, I work right here now.
Okay, ma'am. I heard you said just be quiet. Let me get an answer.
I've been with this company since we started it. I have no idea who she is.
Okay. She doesn't think it's a problem. If it is, we'll come on the 16th and we'll do another agency. But I think the Portsmouth Municipal Court will order you also there. So, okay, August the 16th is your next hearing, one way or the other. If you're in treatment, that's fine. I need to know you're either in treatment or here at the court on August the 16th.
And I just text Judge Mallory's bailiff so he's aware of the situation.
Okay, thank you. August 16th is the next hearing. She has no OR bond from this court.
Thank you.
You're welcome.
State of Ohio versus Ronald L. Remy II, case number TRD 05-1273. Heather M. Robinson is on deck.
Ronald Remy II. You're Ronald Remy?
Yes, sir.
Mr. Remy, I'm Judge Capper. Looks like you got picked up on a warrant for failure to appear on a sentencing hearing way back in 2005 on a driving under suspension.
Yes, sir.
Do you admit or deny that?
I admit that.
Do you have an explanation for not coming?
Well, actually, the place that I was working at the time, they had a trainer come in to train me for a promotion. Once they get on to the next training, I couldn't be there for that, so I had to go forward.
Okay, well, it was a long time ago, so you couldn't find a day to get in here between 2005 and now?
Well, I guess not.
When did you get picked up on this warrant?
Yes, sir.
Okay, so you spent one day. Can you pull up this? It's 05-1273. Okay, how do you plead to the charge? It's alleged this happened on May 21st, 05. at 11:45 PM in Perry Township, driving under suspension.
Well, I was not aware that my license is suspended.
Okay, you pled guilty, it looks like, back in 2005, so do you want to change that, or you want to stay with the guilty plea?
I'll stick with the guilty plea.
Okay. I'll accept your guilty plea. Let me look at what the officer says here. Defendant was involved in an accident, but you were not at fault, but you were under a suspension of your driving privileges. Okay. Since you weren't at fault in the accident, but you were suspended, but you missed, I'm just going to impose a $100 fine and court costs. Give you a final pay date of November the 12th. So if you pay it by then, we're good. If you don't pay it, we'll send it into the Ohio BMV, and they'll send it to, I'm assuming you got a Kentucky license, right?
I have an Ohio license now.
Okay. Well, we'll send it into the Ohio BMV if you don't pay it by November 12th, and they'll suspend you.
I'll have it taken care of in the next couple of weeks.
Okay, that's it. You'll get out of jail today.
Thank you.
You're welcome.
At the jail, State of Ohio versus Heather M. Robinson, case number CRB 24281 A and B. Your Honor, State of Ohio recalls Jacob Little, who is on Zoom too, and he is valid in Colorado.
Okay, all right, so Jacob Little is still there, I take it? All right, Mr. Little, since you were, I'm going to just dismiss the whole case since you got charged with the driving under suspension, and it sounds like that was a wrongful charge, not on Ohio part, but Colorado didn't process the paperwork correctly, so I'll just dismiss the whole thing. You had a minor. Case is dismissed, you're free to go.
Is there anything else that I need to do for the court itself?
You do not.
Am I free to leave the Zoom call, sir?
You are, and if you want to get a copy of the judgment, you can get that from the clerk. You can pull it up on the court. The court has a website. You can pull up your case and check to make sure it is dismissed on there if you want.
Thank you very much for your time, sir.
You're welcome. All right, Heather Robinson, 24281. This was set for a pretrial on June 24th of this year, and it looks like Ms. Robinson did not appear for her pretrial on a theft offense from Walmart. All right, Ms. Robinson, and Mr. Thompson is your lawyer. He's not here right now. So, do you admit or deny you failed to appear for your hearing?
I admit it.
You got a good reason for not coming to court?
My wife was arrested a couple days before, and I had a broken phone and everything, and it was just a lot going on at home with my parents being in the hospital, my daughter being in the hospital. That's still no excuse, and we don't have any excuse.
Okay. Well, I really can't do anything on your case since your lawyer's not here. Can you post any kind of bond to guarantee your appearance?
I cannot today, no. I said my parents were both in the hospital and everything, so.
What happened to cause you to get arrested?
So for me to get arrested?
Yeah, what caused? Usually, in my experience, the sheriff doesn't come knock on your door when you don't appear for a pretrial on a shoplifting case. They just don't do that. So something had to happen to get you arrested. What happened?
My boyfriend was driving, he got pulled over and I wanted to search the vehicle and found something in the vehicle and nobody would claim it, so we both got charged with paraphernalia.
Oh, so you got other charges too?
I took care of those charges, yes.
Was that in Ironton yesterday?
That was right around the time I missed court, yes. Because like I said, my ride was.
No, I'm talking about why are you wearing an orange jumpsuit today?
Yeah, because I didn't make it to court.
I know that, but,
Yeah.
okay. You had to have some kind of police contact to get you into the jail. How did the police contact you?
I was working in another county, yes.
Okay. What other county? Cider?
Fairmont County, from where I'm from.
When did that happen?
That happened right when I was supposed to be coming in court.
You've been sitting in jail since June 24th?
No, I've been sitting in jail since, about 20-something days ago when I got arrested for
Oh, wow.
that charge. Some report on that.
So you must have had a charge there too in Claremont County?
Yes, yes. Like I said, we got pulled over and nobody was claiming the paraphernalia that was in the car, so we all got, me and him both got charged with it.
Okay. You still live in Minford?
Milford, yes.
Milford, I'm sorry.
Yes.
It does say Milford. I just look at that and I think of the mighty, was it something?
Mighty Midford Falcons.
Mighty Minford.
That's a different,
Milford is a different place.
yeah.
That's in Ohio. Minford is in Ohio.
Is this case still pending?
It's still pending.
Shoplifting?
Shoplifting. But she has a lawyer,
Heck.
Mr. Thompson.
Maybe we can get him on Zoom.
You want to try to text him?
Sure. What's this young lady's name?
Heather Robinson. She took a drug screen here on May 20th and was negative.
I'm also in treatment right now.
Where?
I do it online through Work at Health. I see them once a week.
Where's that?
It's on, I do it online.
No, but I mean, well, bad question. Where do you live?
Where do I live?
You still live in Milford?
Yes, I do.
What county is that in?
That is Claremont County.
Which is where you got your charge?
Yes.
Is that,
I've been trying to
is that next to Brown County?
Yes, it is.
She didn't come to court on shoplifting here. Okay, we're trying to get a hold of your lawyer to see if we can handle something on today. So we'll recall you once we try to get him.
State of Ohio versus Savannah Spurlock, case number CRB 24495. And Amber Thompson is on deck.
Okay, ma'am, are you Savannah Spurlock?
Yes, sir.
Your charges were faxed to the jail this morning at 10:30, so if you don't have them, they should be down there in the jail somewhere. And the charge is theft. You've been charged with a theft offense.
Yes, sir.
It's alleged that on August the 7th, you purposely tried to deprive Walmart of an electric shopping cart. A rascal, I guess. With a value of $1,355. So because it's over $1,000, that's a felony, theft. Maximum penalty is a year in jail, $2,500 fine. You understand the charge? Do you have a job?
No.
Do you have any income?
No, I'm currently in high school doing criminal justice. I was supposed to start Wednesday. I'm truly not trying to get in trouble there.
Okay. Well, I don't think I told you your rights, so let me tell you your rights. You have a right to remain silent. You have a right to have an attorney, to have one appointed, which I'm going to do. You have a right to bail and to make the state prove this charge beyond a reasonable doubt. And you live in South Point?
Yes, sir.
You go to South Point High School?
I go to college.
Okay, but that's South Point to College, right?
Yes, sir.
Okay, I'm going to appoint Mr. Stratton to represent you. You got a lawyer here. He's heard your arraignment. Does your family know where you are? Okay.
Your Honor, since she's local and a high school student, I don't think there should be any issue with the alarm on this.
I don't know, it's a rascal.
Well, it's a shopping cart, like for disabled people to shop at.
I know, that's a rascal, isn't it?
Oh, maybe it is. I didn't know
We don't
Rascal
call
made
that.
I didn't know they made a commercial version. But anyway, yeah, she's pretty young. It looks to me like she
She just turned 18 a few days ago.
yeah. And she and a fella decided they were gonna drive away on the shopping cart. So.
I know you're refusing to call it a rascal. So that's.
It's a jazzy, if anything. Anyway, so I think under the circumstances, we probably could recommend an OR bond.
Okay.
What's that mean, sir?
That means you're gonna get out of jail.
Thank you.
What, do you have a phone number? Do you have a cell phone?
And then 740-882-0626.
Okay. And.
Could you say that one more time? I'm sorry.
Repeat that, please.
740-882-0626.
Okay, got it that time.
So school, we probably need to get her back in here before school starts.
Monday?
When does school start?
Wednesday.
Next Wednesday? So Monday?
Yeah.
We'll set it for, do you know where the court is in Chesapeake? You do? Across from the flea market?
Yes.
On County Road 1?
Yes. Will I be getting out today, sir?
Yes, you will. Do your parents know where you are?
Yes.
Do you want your lawyer to contact them or anybody?
Yes.
Do you have a phone number for them?
740-550-8521.
And what's the name on that phone number?
Grace Webb.
Chris Webb?
Yes, sir.
Is that your mother?
That's my grandmother.
Grandmother, okay. Chris Webb. Grace Webb. Grace Webb, okay. Grace.
I'll call her.
Okay,
Oh,
so
Grace.
what I'm going to do, Savannah, I'm going to let you sign a piece of paper that says, I promise I'll come to court when I'm ordered to, and if I do that, I will not have to pay $2,000. Otherwise, you would have to pay $2,000 if you don't show up. You get a warrant for your arrest, you go back to jail, and then you got to pay $2,000. You just have to come to court Monday, and you won't have to pay any money to stay out of jail. Okay? You can agree to that, right?
Yes, what time Monday?
You got to be here at 10 a.m.
I'm gonna go call your grandmother right now.
Okay, so your grandmother, I assume, does she drive?
My uncle does, and her will probably come get me.
Okay. All right, your lawyer's going to call them and get set up for you to get picked up at the jail. $2,000 signature bond. Then you got to be here Monday at 10 a.m. All right. No excuses.
Yes, sir.
Okay. Thank you. So you'll get out here in a few minutes when the paperwork is completed.
State of Ohio versus Amber Thompson, case number CRA 24496 A and B, and Monica Gibbs on that.
Amber, okay. All right, ma'am, are you Amber Thompson?
I'm Amber Billups, sir.
Okay, well, we got two problems, because the charge says Amanda Thompson, so I guess we need to amend.
I guess, is Thompson another name that you've gone by?
Have you used Thompson before, ma'am?
Thompson was my maiden name. I have been Billups since 2006.
Okay. Well, 2006 wasn't that long ago to me, but we will try to fix that. Does the state want to amend the charge?
Yeah, is it Billups?
Yes, sir.
So Amber Billups is your correct name.
Yes, sir.
Do you want to amend to that?
Yes, Your Honor.
Okay, Ms. Billups, you have a right to remain silent. You don't have to say anything today. If you do say stuff, what you say is all being recorded. So if you admit something that helps the state, they could use that against you. Do you understand that?
Yes, sir.
You have a right to have an attorney. So you can have one appointed to represent you if you can't afford one. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Do you understand those things?
Yes, I do.
You got two charges here. Breaking and entering and vandalism. Those are the two charges. The breaking and entering is case number 496A. It alleges August the 6th, 2024, by force, stealth, or deception, you trespassed in an unoccupied structure, and you did so with the purpose to commit a theft offense in that structure. So that's breaking and entering. It's a felony 5. Maximum penalty is a year in jail, $2,500 fine. You're also charged with vandalism. It's alleged the same time and place. You caused physical harm to property that was owned by the Chesapeake Methodist Church, and it's used in their profession. That's a felony 5. Maximum penalty is a year in jail, $2,500 fine. And these charges were faxed down to the jail this morning at 10:39 a.m. So you should have a copy of them. Do you understand the charges?
Yes, I do. Can I say one thing?
Well, you probably shouldn't. You should save it and tell it to your lawyer. Because here's the thing. What you say is on the record. It can be used against you. It can't really help you because it's not the trial, and it could hurt you. So why don't you save it? You know, I'll give you a chance to ask questions rather than make a statement. But do you understand the charges? You don't have to agree with them, and they may be totally false. But do you understand them?
I understand, Your Honor.
Do you have the money to hire a lawyer?
No.
Do you have a job?
No.
Do you have any income?
No.
Okay, I'm going to appoint Mr. Morford to represent you. He's here in the courtroom. He heard the whole arraignment, so he knows what's going on with you. What's the state's position on bond for?
Can I ask for OR, please? I OR'd last time, and I made it to court, and I paid my court fines. I am not a flight risk whatsoever. Please.
What's the state's position on bond?
Your Honor, the allegations are that Ms. Billups was found inside the church. She'd broken in the church and she was sleeping in the church. And that she had drug paraphernalia on her, not paraphernalia, but I guess drug abuse instruments, needles and crack pipes and things of that nature. And she appeared to be under the influence at the time. And this sounds like the kind of behavior that would
I was tired.
Well, she broke into a church to sleep, so we believe she probably needs to be assessed for treatment.
Well, why don't we do this? Would you be agreeable to going to inpatient treatment? That gets you a place to live, food to eat, and treated for your substance use.
If you look to an OR, I will go to foundations today.
Wait, hold it. You don't get to decide all that.
Oh, no.
I'm in charge of that, so quit thinking I'm going to say, well, this is the bond I want to post, this is where I'm going to get a treatment. That didn't work that way. I'm going to decide where you go, what kind of bond you have. All I asked you was, are you willing to go to inpatient treatment?
Yes, sir.
Okay.
And don't interrupt the judge, Amanda.
And don't you either.
I was waiting to do that. Took a breath.
So you've been to treatment before?
One time, yes.
To the counseling center?
Yes.
When was that?
That's been, I tried to go about two months ago.
And you left?
I did. I left, Your Honor.
Okay, well maybe you need an ankle monitor now.
Oh, no, I can go. It's a week. I didn't leave for that.
Okay, I shouldn't have said that. I should have said, I'm getting to be like my millennial children.
I can do
Because
it, Your Honor.
okay, be quiet. There's an order, be quiet. To their kids they ask, would you mind not doing that anymore? Unlike my parents would say, don't do that. They ask them, would you mind not doing that, please? They don't mark out orders, they just ask. So that infers that they get the decision. Oh, no, parent, I don't want to do that. And I think that's the way they take it. So, no, I'm going to give you orders where you're going to go. So the counseling center would be a good place. Do you want to take her back?
Yeah, we'll give her a shot.
But you're going to have an ankle monitor this time, so that I'm upping the ante. Was it out of this court, or what court did you go to the counseling center?
I went myself.
Okay. Well, now you're going to have an ankle monitor. So here's what that means. If you leave this time, one, you're going to be easy to find unless you cut the ankle monitor off. And if you cut the ankle monitor off, you're going to go to prison. You understand that? So you don't have a choice. Well, you do have a choice, but it's a bad choice. And people take that bad choice and go to prison. Don't be one of those people. And you're going to tell me, don't worry, I wouldn't do that. But you know what? I have people that do that. They cut the ankle monitor off. They think, I don't know if they think I'm not serious, or they are only thinking about what's going to happen in the next 24 hours or what they want to do. But they wind up going to prison for cutting the ankle monitor off. I think maybe she needs to stay in this weekend. I don't think she's ready to go to treatment yet.
I'm ready to go, Your Honor. I really am, please.
Well, I think your brain needs a little clarification first.
I swear to God that I will do every single treatment I'm going to do, please.
Well, I'm speaking from experience here, and I'm afraid you're one of those people that I could, and you're probably not going to get, it's probably not going to matter because you're not going to get an ankle monitor today anyway. But I've had people that are still under the influence, they say all this stuff, I'm going to do it, and then they get an ankle monitor and they cut it off and then they go to prison because they're still under the influence.
I'm not going to cut my ankle monitor off, I promise.
Okay, so what I think we need to do is set her for Monday. I'm going to set your bond at $10,000 cash or surety. We need your brain to dry out a little bit, and it will in the next few days. It'll start drying out. Not enough to cure everything that's a problem, but enough that you'll be thinking a little better by Monday than you are today. So, $10,000 cash or surety. Set your next hearing for August the 12th. For a preliminary hearing, which won't be a preliminary hearing, but it'll be on the docket as a preliminary hearing. Mr. Hill.
Well, I'd like to also say, Your Honor, that of course we've had no contact with the alleged victims of this yet, so we're not making any representations.
So it could go on to the grand jury.
It could possibly, and it's just going to depend upon a lot of factors.
Yeah. But regardless of whether it goes to grand jury or not, the best thing you could do for you and your legal case is go to treatment and do really well and get great reports. Anybody disagree with that?
Absolutely not.
Even if it goes on to the common pleas? Because they got a lot of other people they can send to prison that aren't doing well, so don't be one of those people.
Yes, sir.
So look at this as an opportunity. This is an opportunity for you to get clean. Apparently you wanted to before because you turned yourself in a couple months ago to go to treatment. Now you have to go. But you should want to go yourself. Make it something you want to do. But if that won't work, do it because the court's making you do it. And then eventually it's got to become what you want. That you want to get clean and stay clean.
Get yourself back, get clean, and I can help you get a more favorable result here.
We'll see you on Monday at 10 o'clock, just like this, by teleconference.
I'm Monday at 10 o'clock?
Yeah, you're going to be sitting in the jail for the weekend, drying your brain out.
Okay. And then
Hopefully.
Monday I get to make my ankle monitor.
That's the plan.
Okay. Okay.
Okay, we'll see you Monday.
Okay.
State of Ohio recalls Monica Gibbs at Lawrence County Jail, case number CRA 24439.
Yeah, did anybody hear from Lance on Heather Robinson?
Yeah, he's at the doctor. So so he won't be able to help us.
Okay,
He's having some issues.
we'll have to just put it on for Monday. Okay, Monica Gibbs is Mr. Morford's case. It's set for, as of now, August the 16th. She was remanded into custody for not being compliant with treatment.
She would like the opportunity to go to another treatment provider, Judge.
What does it say?
This is what we would want in exchange for that opportunity for her. We would move to amend it to a misdemeanor, and we would ask to delay sentencing with the understanding that if whatever treatment program is approved by the court, that she better do it good, and she better not cause the same kind of problems that she caused at the other place. Otherwise, she's going to have 6 months in jail hanging over her head, and we'll be serious about that.
Here's the only problem with that. She's a West Virginia resident. Well, she just runs back to West Virginia.
Oh, well then, okay, then, yeah, that's right. That's the reason we did that. We've been left it pending for that reason. So, yes, we'd be okay with leaving it pending. She'd have to waive time if the court's willing to let her have a different opportunity. But we're serious about it.
Well, if anybody want to take her, how about the counseling center? That's true. You have West Virginia Medicaid.
Do I have West Virginia Medicaid?
Yes.
Okay.
She has a lot of Medicaid.
We have her insurance, we show her.
Okay. Let's try the counseling center then. So you're going to go to Portsmouth.
Where's that?
It's another little town on the river. It's down the river from here. Scioto County.
Okay. And it is a rehab facility?
Oh yeah, it's a good one.
Okay. Thank you, Your Honor.
But here, I think what you need to hear, Ms. Gibbs, is you got to do what they tell you to do, when they tell you to do it, how they tell you to do it.
Yes, Your Honor.
Because I think that's been a problem from what I see. They ask you to do stuff and you just won't do it.
A little bit different. When I first got there, I was kind of not compliant, but after I got over my detox and all of that, I started complying. I was sabotaged there. There were some people that didn't want me there. So that's what happened, was that I wasn't compliant. I had a complaint that was also filed. But if I was in compliance, I wasn't in compliance, I'm willing enough to say that I did do whatever it is, but I did not do that. Can you hear me?
I can hear you.
I couldn't hear you. I didn't know if y'all were talking to me and I didn't want to.
No, I'm reading some stuff. So,
Okay, sorry.
Ryan, do you still want to try it? Do you need to talk to her, or?
Yeah, I'm gonna call.
Okay, a representative of the counseling center is going to call down and talk to you, and then after he does that, we'll come back.
Okay.
Do you have to be anywhere, Mr. Morford?
Not essentially.
Okay.
Not for about an hour.
Okay. Well, do you want the court's file? It's got the record from Bethesda, and it's got all the little issues. Okay. Yeah, you can come do that.
State of Ohio recalls Heather M. Robinson at the Lawrence County Jail, case number CRB 24281 A and B.
All right, Ms. Robinson, we contacted your lawyer. He's not available today to help you. I can set it for Monday, and I think he can be here then. How do you want to proceed?
I would just like to try to get it done today, if we can.
Okay, if you plead guilty, you're going to basically tell me you want to fire your lawyer and proceed without a lawyer and change your plea. Is that what you're wanting to do?
I know I was doing what I'm charged with, so I think you can do that, so.
Well, that's the only thing you're charged with.
Yeah, and I know I did that, so I'm willing to change it to, I know that's what I did, so.
I'm happy to wait till your lawyer can be here, but you're probably going to have to post, since you didn't appear before, I'd have to make you post a bond, and you're telling me you can't post a bond.
No, but I do have an ambulance right in, it's easy to view the for right in the first about, I know you'll bring me for the fact that it's one more chance, because I'm calling the hospital right now, I'm told just that I'm in the hospital.
Well, that's not going to be an issue if you change your plea. You will have to come back for a review hearing. But I want to make sure you understand, you currently have a lawyer representing you,
Yeah.
Lance Thompson. He is not here in court today. He didn't know you were going to be here because it's alleged you failed to appear for a pretrial in June. You got a warrant, you got picked up on that warrant, and then transported here from Claremont County. So you weren't on the docket. You're just here today because you're in jail and I'm dealing with your warrant. I'm happy to wait till your lawyer can be here. If you want to fire him, I can let you fire him and represent yourself and change your plea. If that's what you want to do, I don't want to force you to do anything. If you don't want to do that, we'll set it for Monday when Mr. Thompson can be here. How do you want to proceed?
Let's set it for Monday, yeah.
Okay, I'll set it for Monday. Your bond will be $2,500 cash or surety. Your hearing is set for Monday the 12th for a pretrial. 10 o'clock. And I'll let Mr. Thompson know. Or can you text him, Mr. Shrugged?
Yeah, I'll text him right now.
Okay, thank you. Heather Robinson is her name, set for Monday for a pretrial. She had failed to appear before. She's in custody.
State of Ohio recalls Daniel L. Turner, case number CRB 23732, TRD 1562, A and B.
All right, Mr. Turner is here.
Your Honor, Mr. Turner made contact with his counselor before he came up here and said that he's been struggling a little bit and is interested in going to inpatient.
Okay. And I see, was it your brother that brought you?
Friend.
Well, you guys look like brothers. I thought maybe it was your brother, because Mr. Sowards texted me that he had convinced you you needed to get a ride today.
Yes.
Right?
Yes, sir.
Okay. Yeah, coming to court's important.
Your Honor, and I'd like to say this about Mr. Turner, he does stay in contact, so, it's not like other people who just completely blows it off. He does stay in contact, so I just want to at least give him that credit, so.
Okay.
Your Honor, if it would be okay, and if it's okay with Mr. Stratton, I'd like to speak to him about doing the QRT program.
Yes,
okay.
that would be fine with me.
He has a felony pending.
And he also has this menacing charge. I don't know if that.
I don't know if that, what
Yes.
They're separate.
his felony is a possession of drugs charge.
F5.
Methamphetamine.
Okay, so do that?
I'll look into it.
Okay, all right. So I guess you're going inpatient, so at Bethesda.
Okay.
I'll meet with him out here before he leaves.
So let's come back then, I'll let Mr. Sowards know he can quit hunting for you. You got others. Well, and on that, what was that lady's name? The sheriff's gonna pick her.
She's already in custody, Your Honor.
Okay, he sent me a picture of her going to jail, I guess. He sent me a picture. Yeah, we got the sheriff standing in the background, and she's getting in the police cruiser. Okay. And then I'll let him know that Mr. Turner showed up. So I'll cancel the warrant.
You have a court date.
Let's set that August 30th date. I had set a bond forfeiture then. We'll just make a preliminary hearing date and pre-trials
Yes.
on August 30th, and we'll get a report in from Bethesda as to how he's doing.
Yes, Your Honor. August 30th, and you'll be going with him. And he has stuff in Kentucky. You have Kentucky stuff, correct? Yeah. Okay, so make sure they know about the Kentucky stuff. Okay? All right. Very good, man. Get this taken care of. All right. And I text Mr. Thompson about Monday.
Okay, thank you.
Thank you, Your Honor.
Okay, I'll put it down.
QRF.
So we'll fully address QRT on the 30th.
Okay. Thank you, Your Honor.
Thank you.
State of Ohio recalls Monica Gibbs at the Lawrence County Jail, case number CRA 24439.
This is Mr. Morford's case. She had a discussion with Ryan from Counseling Center.
Yeah, we're gonna give her a shot.
And give her a chance.
Yep.
Last chance. Okay, you're willing to do it this time? I said you're willing to do it this time and be a model as to what you're supposed to do? Okay, I'll order her released to the counseling center. Do we need GPS or?
We'll keep a tight grip on her if you don't.
Okay. Because otherwise, if I order GPS, it's not going to happen until Monday. What's the state's position?
Well, I mean, she didn't have GPS before, did she?
No, she was just not. She was just a jerk.
I don't think she'll be a jerk, and I don't think she'll run. I hope she won't.
Okay.
So we're okay with
All right, we'll try it without an action, so you can go today, or you release the counseling center. But if this one doesn't work and they kick you out, I'm going to kick you out of this court. You're going to go on to the common pleas court. It's like going from the minor leagues to the major leagues, because they can send you. I can't send you to prison if I want to. They can send you if they get up on the wrong side of the bed. They can send you to prison. So you don't want to mess with that, do you? Act like you're afraid of a little bit of going to prison. It's a real thing. I would be scared to death. When somebody says, well, you need to get up and go to devotions, you don't say, no, I'm not doing that. You say, yeah, I'd be thinking, prison? I don't look good in a prison uniform. I better go, better do what they're telling me. All right? Okay. So I'll make her, let's move her hearing. It was the 16th. We need 2 weeks. So the 23rd, we'll get a report. So her next hearing is August 23rd. She's ordered released today to the counseling center on a $2,500 OR bond.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
We finished in jail.
Yeah.
Okay. That finishes up at the jail.
State of Ohio versus Jade Olivia, case number CRB 24352.
Your Honor, this was the case set for trial today. I understand that the prosecutor's permission, they did not have to appear today. We also have Sergey
Levitt, State of Ohio versus Sergey Levitt, case number CRB 24351. It's Mr. Steyer's case.
I understand these cases were going to be dismissed today.
Your Honor, we reviewed the evidence and determined that we would not have enough to pursue a conviction in either of these cases.
So you're going to be nollie.
That's correct.
Both cases are nollie.
Yeah, and Your Honor, just as a note, they spent almost $900 in this transaction, and I think that the what's in dispute was only like $50. So, yeah. So
Was this a Walmart case? I don't remember. Was it
it was a Walmart case, and I think there was some mistakes done that.
Self-checkout?
Yeah.
And the video pixelated right at the moment in which the theft was supposed to have occurred, and none of that is on the video. So I felt that probably, and given the fact that they purchased a whole lot of expensive things and they scanned it all down, so.
Yeah, so it's one of those.
Don't go, well, should leave it alone. Don't say anything.
State of Ohio recalls Jonathan Bowman, case number TRC 221598, CRB 22194, CRB 16947. It's in hold here, Your Honor.
Jonathan Bowman's in the back, I believe.
That's when I feel
It turned out later.
All right, Mr. Bowman, I placed in custody because he had failed to appear for community service on a date the court had ordered him to. What say you, Mr. Bowman, about that? Well, I think that was in lieu of payment or getting something done on it.
Yeah, but I have been doing little side jobs and possibly just to, I made 3 payments on my bonds now. Who knows, could have done it again, but,
You are correct on the judgment, I don't know why this happened, but on your judgment entry for OVI, it says 0 hours of community service, which is very unusual. Oh, because it was concurrent with some prison time, I guess. Okay, and did you pay anything today?
yes, sir, I paid $41 today.
Okay. All right, I'll give you another review hearing date. September, are you working?
I'm currently waiting on my orientation process for Walmart.
Okay, so you don't know what your work schedule will be?
I
September 16th, that's a Monday. September 16th, your next hearing at 9 a.m. Right, you can be released.
We're finished here.
Okay, court's adjourned.